like medical attendant. All white.
Any mention?
Please, Lordship, I beg to mention item number 7. I have informed the respondents.
No, what's
Lordship.
the reason for adjournment?
The conducting senior counsel is having some personal difficulties, Your Lordship.
What's the matter about?
This is ex gratia payment.
Okay. Other side, nobody's here.
I have informed the other side.
Yes.
I appreciate this matter. 3 weeks, Your Lordship.
3 weeks. Okay, 3 weeks. No objection. Okay. Yes.
Anyway.
Item number 1.
May it please your lordships, I pray that the matter may come up at the end of the board, lordship.
This board ends very fast. Division bench. Yes.
Have you obliged?
2.
Well, it's 1 and 2 are connected.
Item number 3.
Lordship, this is an appeal which has been filed by the victim against the acquittal order passed by the appellate court, first appellate court. Your Lordship, the petition which has been listed is for seeking leave of this honorable court to file the appeal. What has happened actually in this appeal, that the exhibits or the documents which were seized by the investigating agency during the course of trial during the course of investigations were sent along with the charge sheet. Now, when the witnesses came before the court, it was informed by the public prosecutor that those material exhibits which were seized by the seizure list are not found in the Malkhana. As a result, what has happened, the first trial court and the first appellate court has held that no evidence have been produced with regard to the offence in questions. The offence is, Your Lordship, we are the bank, Apex Bank, and there is a
quantum. What is it's regarding disappearance of money?
Yes, Lordship, 21 lakhs, and we are the complainant. We have filed the complaint before the police. Police has investigated and submitted the charge sheet, and along with the seized documents, which are very important for the purpose of trial.
You mean to say that the entire materials in the custody of the court
Yes.
were never presented?
But those were found to be missing, and neither the trial court nor the appellate court has taken cognizance of these things and have made an attempt to produce the secondary evidence. But because we had the secondary evidence of some of the documents, we kept the photostat with us. But since the case was conducted by the state, we had no opportunity to produce those documents.
Yes, Mr. Guru.
My lord, this is a case of second appeal, my lord. Firstly, my lord, in the second appeal, my lord, we cannot enter into the evidence, my lord. We cannot. 7 except, my lord, if there is a misinterpretation of any law, my lord, that only has to be looked into, my lord, not the evidence. We cannot enter at all. Now, that apart, my lord, because this is a leave, that is up to the discretion of the Honorable Court.
BNSS. Here.
Lordship, I may point out, Your Lordship may see section 413 of the...
That's for leave to appeal, correct?
Yes, Lordship. 2023, Sanhita 2023, section 413. Section 413, Your Lordship says...
1 second. Yes, no appeal.
No appeal to lie unless otherwise provided. No appeal shall lie from any judgment or order of a criminal court except as provided for by this Sahitya or by any other law for the time being in force. We are here, this proviso is applicable provided that the victim, we are the victim here, provided that the victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused or convicting for a lesser offence or imposing inadequate compensation, and such appeal shall lie to the court to which an appeal ordinarily lies against the order of conviction of such court. Your Lordship, the CRP section was 372. If Your Lordship see section 372 of the CRPC, Your Lordship will find that this proviso was not added to section 372 of the CRPC. It was added newly. Your Lordship will see section 372.
No, but what was it amended after 2018?
Yes, Lordship.
372, what 70 reading?
Yeah, here 372 says that no appeal to lie unless otherwise provided.
1 second. Just give us 1 minute. See, it was inserted in this proviso was there in CRPC also, because it was inserted since 2009. CRPC was again amended 2018.
Yes, Lordship.
If you see my copy, same proviso was there.
1. Yes, it was added in 31/12/2009. Earlier it was not there.
Yes, now
Earlier,
so
earlier
it's
it was not
part of
there.
merit.
Your Lordship, here, what does it mean that one right of appeal is conferred to all the parties? Even victim has got a right to file an appeal, because one right of appeal is conferred under the law. Your Lordship will also see section 419. 419. Appeal in case of acquittal.
Yes.
Appeal in case of acquittal,
Yes.
save as otherwise provided in subsection 2 and subject to the provision of subsection 3 and 5. The district magistrate may in any case direct the public prosecutor to present an appeal to the Court of Session from an order of acquittal passed by a magistrate in respect of a cognizable and non-bailable offence. The state government may in any case direct the public prosecutor to present an appeal to the High Court from an original or appellate order of acquittal passed by any court other than a High Court, not being an order under Clause A, or an order of acquittal passed by the Court of Session in revision. Your Honor, in this case, the state has not come forward to file any appeal against the acquittal order.
Will issue notice to the private respondents?
Your Lordship, so far this petition is concerned, unless Your Lordship grant the permission to file the appeal, possibly to my understanding.
Let them have they wouldn't have an opportunity to object to your.
No, Your Lordship, this is the discretion of the court. After this is decided.
Discretion of the court. That's why we issue notice. Because we are still not sure with whether a second appeal will this is a second appeal.
Yes, Lord.
Is available or not. That's the only thing.
Let
them come.
No, there is no problem in coming in their coming.
Miss case number 50/2025. In appeal number -2025. Stop. It's an application under section 4193, read with section 413 of the BNSS 2023. Seeking leave of this court to prefer an appeal against the acquittal of the opposite parties 2 and 3 by judgment dated 2 and 3 by judgment order dated 14/11/2023 passed by the Chief Judicial Magistrate and subsequently upheld by the Sessions Judge East Garo Hills by judgment and order dated 16/12/2024. Stop. Mr. R. Guru is present on behalf of the
Respondent number 1.
Notice, yes. Sorry, issue notice. Mr. Guru is present on behalf of respondent number 1. Steps to be taken for serve notice upon the 2 opposite parties within 3 days, this up to 2 weeks. Let us hear an interesting point.
My lord.
Your Lordship.
Item number 6.
Just
Second call, item number 1.
Yeah, please, my lords.
Yeah, what is this?
Well, the issue here is, there is an amnesty scheme of the Government of India, my lords, insofar as payment of GST is concerned. Now, that scheme subsequently got formulated as Section 128A of the Principal Act, that is the GST Act, my lords. Towards that particular scheme, my lords, the petitioner has made a payment of initially of 19 crores. Thereafter, my lords, on a request by the GST department, my lords, we have made a payment of additional 4 crores. So, roughly, my lords, we've paid about 24 crores to the department as on today. To, my lords, put an end. What that scheme basically envisages is, my lords, towards any claims of the GST department, the principal amount is to be paid, the penalty and the interest is waived off. That is the purport of Section 128. My lords, I'll take your lordships through that. Now, after we've done all this, my lords, now there are two circumstances under which there can be a existing dispute, my lords, which can be resolved under 128. One is under Section 73 and one under Section 74 of the GST Act. Now, insofar as we are concerned, my lords, there are two periods which are concerned. One is 2017, 2018 and 2018 to 2021, 2020, 2018 to 2020. Now, in
So, for this period, didn't pay GST at all.
No, it is paid, my lords. There was a disputed amount.
Okay.
There was a disputed amount. Now, in so far as, my lords, the period from 2018 to 2020 is concerned, my lords, there were some appeals that were filed by us against the, my lords, order that was there. The commissioner holds, my lords, that this is essentially a demand under Section 73. My difficulty is, my lords, why I am before your lordships, I must be frank. If it is only a demand under 73, my lords, I am liable for a waiver of penalty and interest under 128A. If it is under 74, my lords, I am not liable. So, for the period 2018-2019, my lords, they say that the original demand is under 73. The distinction between 73 and 74 is, my lords, in 74, it is, my lords, suppression of fact. Now, insofar as 2017-2018 is concerned, my lords, the Joint Commissioner passes an order saying that, my lords, there is suppression of fact. Now, the reason why they say suppression of fact is because they say, my lords, we filed the returns, the 3B returns later, that also on a requisition made by the department. It's not that we didn't provide the papers, we provided the papers, my lords, but it was at a subsequent date. So, to that limited extent, my lords, we are here before your lordships. The department, my lords, initially had indicated to us that they are willing to consider us for the purposes of the amnesty scheme and give us a waiver of the interest and the penalty. Subsequently, my lords, this issue of 74 has come in. And, my lords, that basically puts an entire, if I may put it so, my lords, it blocks us from participating in that particular scheme.
Where's 73? Can you see?
I've prepared a compilation, my lords. I'll just take it.
Where is that quoted in your petition?
My lords, we've prepared a compilation of all the documents.
Yes. You have given Dr. Mojika a copy.
One copy for.
Yes.
My lords, may kindly come to page 12, my lords, of the compilation. My lords, 128A. This was the scheme which has now become part of the Act. Waiver of interest or penalty or both relating to demands raised under Section 73 for certain tax periods, notwithstanding anything to the contrary contained in the Act, where any amount of tax is payable by any person chargeable with tax in accordance with a notice issued under subsection 1 of Section 73 or a statement issued under subsection 3 of 73, and when no order under subsection 9 of Section 73 has been issued, or an order passed under subsection 9 of Section 73, and where no order under subsection 11 of so-and-so has been passed, well, I'll skip this, pertaining to the period from 1st July 2017 to 31st March 2020, or a part thereof, and the said person pays the full amount of tax payable as per the notice or the statement.
So, you see, you're in that window.
I have paid that amount, well, it's the principal amount I've paid.
Since you paid that window, that means you're not liable to pay.
We are saying, my lords,
penalty.
no, for the purposes of them considering it, my lords, I have to be in 73, I cannot be in 74. I am
That's
saying,
what
my
you're
lords,
claiming. You would say that whatever pay you paid the principal amount, so under 73, and whatever tax assessed you paid that.
I've paid that.
And
Now,
so like
at this
and
stage,
at this stage, and
at
now
this
like you're not liable for any
penalty
further
and interest, my lords, for that, for considering that, my lords, they have to first allow me to be under 73 and not under 74.
Yes,
Only
Dr.
reason
Mosika.
for 74 is
I'll file affidavit.
File affidavit then.
Well, it's two small prayers. Well, there's one small little issue in the filing. Union of India has been made respond number 1. Well, Union of India is not a necessary party. It will basically be the GST. Well, it's 2,
strike
3,
them
and 4.
out.
Well, Lordships may kindly strike out respond number 1.
Heard Mr. K. Paul and Senior Counsel with so and so for the issue notice stop. No, sorry, so Mr. K. Paul at the outset has submitted that the union, the respond number 1 in India, which is, or the Union of India, which has been arranged respond number 1, in this case not necessary party, prays that the said respondent be struck off from the array of parties. Stop. Submission noted. Respond number 1 Union of India, the Finance Secretary,
Penalty
Finance is hereby struck off as necessary party. Stop. Next, on hearing legal counsel party issue notice. Notice Dr. N. Mosika for all.
Yes, ma'am.
Right, N. Mosika, Leonard DSGI with so and so is present. Accept notice on behalf of all of the remaining respondents. Respondents will be renumbered as 1, 2, and 3. As such, no further notice called for. Dr. N. Mosika under prayer on the praise email. How much time?
3
2 weeks.
2 weeks. 2 weeks.
2 weeks to file necessary affidavit. Yes.
Lords may kindly protect me in the interim, my lords. They should not take any coercive action against me till
There's no prayer.
But my lords, the only issue is that I've already paid that entire amount. If I had not paid, my lords, I could not have made that prayer before your
Let's
lordship.
see after 2 weeks.
Well, in 2 weeks, under 122, the extent even it goes to arrest. I'm only saying, my lords, without leave of this court. If they want to take, my lords, my lords may put it, no course of action without leave of the court. If they want to take something, my lords, they can come before your lordships.
Where's the interim prayer?
I have not made, my lords, there is no written interim prayer, my lords. I'm just requesting this. If they want to take any action, my lords, they may come before your lordships. Only with the leave of this court, my lords, they may proceed.
Yes, Dr. Mosika, you have any objection to that?
In my humble son, there is no scope for interim order, my lord.
Let them come for leave, my lords. I have no
2 weeks. Let them come instruction files. Nothing that can't be repaired. You have not made a prayer, Mr. Paul.
I understand, my lords.
Yes.
I want a sticky wicket on that. My lords, may kindly grant me liberty, my lords, if this
Yes, of
occasion
course.
arises, my lords,
You
we
have
may move an
liberty,
appropriate
You can
application.
file it. Application be considered. 2 same orders.
My lords, 1 and 2 same. Highly obliged.
Hi.
Hearing, item number 8.
My lords, in item 8, my lords had permitted us to bring those documents on record by way of an affidavit.
You're paying to the council?
My lords. There's some.
What letter day 19/2023?
Well, this matter was heard at length. Where that act was sent back.
Yes, no, the issue is very simple now.
Lordships.
Whether where to send back, whether it wasn't placed. It's only submissions that are not placed for the house.
Well,
the level executive committee itself, the amendment was done and sent back.
Well, as I had pointed out before, Lordships, that would not be a relevant consideration, which is why your Lordships had then permitted us to bring this letter on record. Well, as the affidavit is ready, it's gone for signing. May I pray for a day's accommodation? We'll find it in the course of the
2 weeks, yes. This matter of 2 weeks to enable the London Senior Counsel or to enable the respondent to bring on record the affidavit containing the letter dated 1/9/2023. Yes.
Highly obliged.
Okay.
My lords had also indicated in this there's a larger issue involved, my lords, so that would throw light on this.
Many bills like this.
Lordships, lot of issues on at least 2 matters that I have done, my lords, on either side, where the EC has taken a decision.
It's a very important issue, my lord. Very important issue.
Pronouncement of judgment, item number 1.
Yes. In present circumstances, what can be seen is that the petitioner is continuing in office due to the lack of clarity in the entire matter, though as stated there is discord, discontent and no consensus on the ground, with admittedly half the recognized electors, apart from other bodies, opposing him, which has led to a deadlocked administration. This discord will naturally have an adverse and a negative impact on administration and non-post authorship, affecting the entire populace of authorship until and unless the matter is resolved one way or the other. On this consideration, this court being a court of equity, to balance the competing claims and public interest, and take into account inherent democratic process in green and customary elections to such judicial posts, inasmuch as it appears that no just solution can be arrived at otherwise, deems instant case to be a fit case for his counsel respondents to resort to section 6, clause 2 of the Act 1959, which provides for referendum as follows. The referendum and it's quoted, direction to the mind of the court will be efficacious and suitable inasmuch as it settle a question once and for all, shorn of all other legal technicalities, which if given minute consideration will bog down the possibility of a fair and clear decision. It may be added herein that this provision had also been resorted to in the year 2004 in the case of Milliam versus Cassius District Council. In the result, MP order dated 2/12/2024 is modified and interfered with to the extent that paragraph 4 thereof is squashed and set aside, and is made clear there shall not be a second inquiry presently. Whatever paragraph 5 is upheld, an administrative officer designated therein who will take charge and look after the administration of non-post authorship till the final outcome of the referendum is arrived at and appropriate orders passed thereon by executive committee. The MP notification dated 3/12/24 notifying the order dated 2/12/24 shall also stand modified to the extent of the order dated so and so as indicated. In consideration of the situation prevailing, it is further directed respondents 1 to 4 shall complete the exercise within a period of 3 months from this order. Petitions accordingly closed and disposed of. I hope it satisfies both sides. But there'll be no so, but presently, but the thing is that it'll never be resolved otherwise.
Any mention?
May I please, Your Lordship? Item number 32 of the hearing list, Your Lordship. I humbly pray that matter may be listed after 2 weeks.
After?
2 weeks.
Yes.
Much appreciated.
Please, Your Lordship, I beg to move a mention memo for listing of an urgent motion item, my Lords. Lordships will recall last week I had moved a mention memo. There has been some change to that. We could not file it today. I'm praying for listing of this item today, my Lords, because the last date of the submission of the bid is tomorrow by 2:30, my Lords.
You should have moved it when you took permission that time.
My Lord, I understand, my Lords. I sincerely apologize, my Lord. There were some changes. The bid closes tomorrow, my Lords. That's the last date of submission.
Before lunch?
Lordship.
Yeah.
Highly obliged.
I have one submission to make in this matter, my lord. I have just seen the petition, my lord. The tender condition, the tender is of 15th May, my lord. And the petitioner is moving now, my lord. And the condition is, one of the condition is that the pendency of the criminal case against the entity is one of the ground for to declare it ineligible, my lord. That condition was...
What case is pending against you?
There is a CBI case, my Lord, against me.
Who are you?
I am a company.
What company are you?
It's a construction company, my Lord. I'll satisfy, my Lord, that this clause itself is arbitrary.
Yes?
CBI filed the charge sheet also, my lord.
Only filed a charge sheet.
It's long, the case.
No, in Guwahati, my Lords. Charge sheet has been filed, charges have not been framed till today.
And the prevention of corruption, my lord.
Correct, my Lord. I'll satisfy, my Lord. I'll satisfy. I'll try to satisfy, my Lord.
Let him move it. Let's go.
May have it tomorrow, my lord. May have it
tomorrow, my Lord, 2:30. This is the last date.
Mr. Sen, we can't give you the indulgence.
No, I understand.
If the tender has been issued since 15th of May,
Lord, I completely understand.
On 25th of
I completely
June.
understand.
Yes.
No, Lordship is only permitted today, my Lords. Kindly let it come up today.
Okay, let it come before
Lordship.
lunch.
Lordship. Obliged.
Yes.
My colleague will assist me, Lord. in that
Yes,
case.
yes. Are you back in the country?
No, my lord. That's why I was saying that
Okay, yes.
because here it is a bit late. So
Yes.
Wait, please,
Yes.
Your Lordship. Your Lordship, I beg to mention item number 31, Your Lordship.
Yes.
The conducting counsel is indisposed, Your Lordship. So I pray that the matter may come up after 1 week, Your Lordship.
Yesterday looking very fit.
Today he's not well, Your Lordship. He's having high fever, Your Lordship.
Serious objection to that. First thing, Your Lordship, more than two dozen adjournment have been sought on this ground.
What is the case about?
Secondly-
Why are you avoiding hearing?
It's an Ukma matter. Your Lordship, we have prepared yesterday, but all of a sudden he is not well, Your Lordship. He's having high
You'll
fever.
have it after 1 week, Mr. General. Yes.
And only on the date of hearing he fell sick. And
No,
the
Lordship,
next day he is okay. I
No, Your
find
Who's
him
to say
there.
when you fall ill?
To the respected senior, Your Lordship, he was well yesterday, Your Lordship. He came to court also.
Yes.
But today, due to unavoidable circumstances,
Just
Your
wish for his good health. That will be the next year. Yes. 1
Your
week.
Lordship, more than 2 dozen, Your Lordship. Just
Your Lordship, similar
next week,
prayer
Your
for
Lordship,
item-
they should not ask this adjournment because
Yes. Adjournment period on behalf,
number.
mentions me on behalf of the petitioner, whose arguing counsel stated to be not well stopped. Mr. V.K. Jindal has raised strong objections of an interest of justice, and as the current counsel indisposed this matter of the 1 week, they expected that the matter shall not be adjourned any further. Otherwise, you argue the matter next day. Yeah?
Your Lordship, 2nd June, 2nd June.
You take any date you want, Mr. Jindal. Yes.
2nd June. Huh?
2nd June is already gone.
No, 2nd July, sorry.
Yes.
Your Lordship, similar prayer for item number 36, Your Lordship.
36. Yes, who's there?
I'm there, my lord.
You have objection?
No, no, I have.
2 weeks, yes. Yes.
Highly obliged, Your Lordship.
Yes, make it quick. Who's mentioning?
Your Lordship, I beg to mention item number 35.
Number?
35. Item number 35.
John Dalton.
John Dalton.
You're for the petitioner.
Yes, I
Who's
pray for 2
the
weeks.
respondent? Yeah, objection.
Look, this matter is a similar matter has been disposed of by this honorable court.
What's the matter about?
This is a land acquisition.
Acquisition matter.
Garvels, NHIDCL.
Where's Mr. Day? Sorry.
We just want to go through the judgments which has been passed. So
I've annexed
just
with the
1 week.
affidavit judgment.
1 week, okay, 1 week. After 1 week, yes. Let him go through. On the prayer petition, yes. Yes. 1 week.
Please, my lords, I beg to mention item number 38. The conducting counsel has some personal difficulties, ma'am.
Who's on the council?
Mr. K.P. Bhattacharya.
No objection, Your Lordship.
Yes. 1 week?
1 week.
Yes.
Much obliged, Your
Yes.
Lordship.
Your Lordship, I beg to mention item number 40.
Number?
Number 40, Your Lordship.
30?
40. I pray that this matter comes after a week, Your Lordship.
Who's the other side? Where's MS EB Pasa? You inform them?
No, Your Lordship.
Then you inform them first, yes. Yes, come on.
Supplementary list item number 2.
Yes, Mr. Pala.
Number 25, Your Lordship.
What's wrong, 25? You want to
Mr.
update it?
Your Lordship.
Then?
Bring some time, Your Lordship.
Yeah,
No objection, my
objection?
lord. No.
Where's Mr. Yubin?
Yes, them.
Okay, yes, after 1 week. Yes.
Obliged.
Is part heard, the Chimti Kharungwar?
Yes, Your Lordship.
Is it MPSC matter?
Lordship.
Yes.
Obliged.
Madam.
Item number 2.
See here, this is a case where I have challenged the order of my cancellation of fair shop license, Lordship. My lord will
already cancelled. Where's the cancellation
already.
order?
My lord will kindly come to page number 15, Lordship. That is the show cause, Lordship.
You are appointed 23.
I'll come first the show cause, then I'll come to appointment, Lordship.
Yeah.
My lord, show cause will find, Lordship. May I read, Lordship?
Yeah.
In cognizance of the press clippings, the Shillong Times dated 11/11/2023 titled Union 6 Cancellation of Licenses or fair fresh shop dealers in Garo Hills, and based on the complaint letter submitted by the President of All Meghalaya Minorities Labour Union, New Whitebury, Srimati Sonso, fair fresh shop dealer of Feshekandi second, third, center is hereby show cause on the following allegation, Lordship. My Lord, the allegation will see, Lordship. Distribution of NFSA and PMGKY food grains to beneficiaries during the period of COVID-19 was irregular, Lordship. The sole allegation, Lordship, because NFSA, Lordship, this is the 5 kilo rice is being given under the National Food Security Act, Lordship. But PMGKY, Lordship, Pradhan Mantri Garib Kalyan Anna Yojana, Lordship, that was given during the COVID period, Lordship. So the entire allegation, Lordship, because of the during the COVID period, Lordship. Now my Lord will see, Lordship, the license was issued, Lordship. Lordship will.
What about the second allegation?
Second allegation, that was also same allegation, Lordship.
It's for the same period.
Same period, Lordship. No. Same period, Lordship. Deduction of so and so forth, because the allegation was with regard to the allegation was with regard to that COVID period, Lordship. The complaint was lost in November 2023, Lordship, and that too also in 2025, the civil subdivision supply, Lordship, he took cognizance of the press clipping, Lordship. Then he taken cognizance and he has issued the show cause notice, Lordship. Now Lordship will kindly see, Lordship, my appointment, Lordship. My appointment will page 14, Lordship.
Yes.
This is the appointment was issued as per the new order, Lordship. Prior to that, I was holding a license under different rule, Lordship. Now my Lord will see the license was given for a period of 5 years. Para number 2. The validity of my license is 31st December 2027, and these are the terms and conditions of the license given, Lordship. Now, kindly see the input.
The cancellation. Let's see the cancellation.
Lordship, page 18, Lordship.
Yes, come there. On what grounds they have cancelled?
Yes, Lordship.
Yes.
I'll just read, Lordship.
Yes.
Order dated so and so as per the provision of section 13 of the Meghalaya Food Grains SK Oil Public Distribution System Control Order 2022. A show cause notice has been served to so-and-so, fair fresh shop dealer of Feshekandi 3, bite number so-and-so, based on the complaint petition relating to irregularities in the distribution of food grains to the beneficiaries, and accordingly an inquiry has also been conducted by the Sub Inspector of Supply so-and-so, that the undersigned found the show cause reply of so-and-so unsatisfactory and observed that violation of the provisions of the following orders, Lordship. Now section 24 of the Meghalaya Food Grains SK Oil Public Distribution Control Order 22 and section 3.
No, but Mr. Sheikh is saying that your cancellation is based on the allegations that you in the year 21 or something that happened.
This was from 22 to 2022, Lordship. That was prior to the issuance of license. Now what section 13 says, Lordship? My Lord, what does the section 13 say, Lordship? My Lord, this is the control orders rule, Lordship. There are two conditions, Lordship, where license can be cancelled, Lordship, as per section, because the order was passed by invoking the power under section 13 of the orders, Lordship. May I read, Lordship? If any fair price shop owner of SK Oil dealer, either by himself or through his agent or servant acting on his behalf, contravenes any of the provisions of this order or any of the terms and conditions of the appointment, then without prejudice to any other action that may be taken against him, the authority issuing the license may, after giving an opportunity of hearing and representing his case, suspend or cancel the license. Here, Lordship, if I violate any of the terms and conditions of the license granted to me, or any of the conditions, yes, contravene, or any of the contravene or provision contravene under this rule, Lordship, that is the 2022 rules, Lordship. Now, when the incident happened, Lordship, in 2022 till 2022, Lordship, that was prior to my issuance of the license. Now, whether I have violated any terms and conditions of this license, or have I contravened any of the provisions of this order, Lordship, then they can exercise this Rule 13, Lordship.
No, they don't file affidavit since already cancelled. Who's temporary? Who's running it?
My lord, this is a vigilance committee as per the law.
And if the reply, my lord, we have made the provisional arrangement, and in reply there is an admission, my lord, that in reply, if the lordship will see paragraph page 16, there is an admission of the wrongdoing on the part of. We will file reply, fair prices of honor, my lord, and the detailed inquiry was conducted by SDO, my lord, and a proper process has been followed, my lord. So we will file reply, detailed reply, my lord, already.
Since you already cancelled,
my lord, only my
there's no question of interim order.
No,
yes,
Lordship, I am not saying any. I am not seeking any stay, Lordship. At least no third party right should be created. Otherwise, my writ will frustrate my writ petition, Lordship. No problem that there is temporary arrangement. Government can take care of that.
Yes, heard Mr. S. A. Sheikh in the council for the petitioner issue notice.
All the respondents, Your Lordship.
All the respondents, Mr.
Yes.
General MS that now can be present behalf of the respondents. No further notice called for. Just after 2 weeks for instructions or affidavit. Yes. We're not passing any.
My lord, only that no. At least my lord.
It's understood that
yes, Lord.
Of food grain shall not be disturbed.
Yes, Lord. Only that appointment of third party right, Lordship. That is the only the thing, Lordship. If they I have made a prayer, Lordship.
Lord, this is a very serious case where the person has admitted, my lord. If it's 16,
where's the prayer?
My lord, I have filed a miscase, Lordship.
And it's not confined to court
affidavit.
Not
miscase.
140, Lordship. I am not seeking for stay, Lordship. At least that will frustrate my writ petition, Lordship.
You asked this applicant for staying
my lord, in the pleading, Lordship, I have that apprehending that there is a.
There is no prayer, my lord.
There's no prayer.
Yeah, there is no prayer, my lord.
My lord,
you have to come fresh miscase, yes.
My lord.
Item number 3.
2 and 3 both are
same.
Same order.
Daily list item number 1.
May I please, Your Lordship? Your Lordship, we received some documents. Your Lordship, I am praying for the 2 weeks time to file our affidavit, Your Lordship.
You have for whom 5 to 8?
5 to 8, Your Lordship.
What about 1 to 4?
I have filed my affidavit.
Yes, you are Mr.
E. Ahmed. E. Ahmed.
You have placed for the 2 weeks time for affidavit. You have after also, yes.
Item number 2.
My lord, we have already filed our affidavit in opposition, my lord.
You want to 6?
Yes, my lord.
Yeah, for whom?
From respondent, all the respondents, my lord.
You have Mr. M. K. Mazumdar?
Yes, my lord.
What about number 7?
He has not entered appearance, Your Lordship, instead of receiving the notice.
Number 7 whom?
He's a private respondent, Your Lordship.
Who is he? What is?
One of the staff working together with the petitioner, Your Lordship.
Rajendra Trivedi. He's been served, sure.
Yes, Your Lordship.
Yes, you must be having contact with him. He's working in your school.
No, my lord, I don't have any instruction on
No
that. instructions? No, my
Yes,
lord.
though notice has been served. You already filed affidavit, correct?
Yes, my lord.
It's ready for hearing.
We pray for some time, Your Lordship, to file a rejoinder.
MS Arkhasian prays for 2 weeks time for rejoinder. The affidavit is filed by respondents 1 to 6. Stop. With regards to number 7, in spite of service notice, there's still no appearance on his behalf. So, your name, sorry.
SM Marak, Your Lord.
SM Marak, no? Yes. Mrs. Marak appearing for the respondents is also requested to alert respondent number 7. His appearance necessary to appear in the next date is just after 2 weeks.
Item number 3.
May I please, Your Lordship? I'm praying for some more time to file rejoinder, Your Lordship.
Yes. What about who has filed affidavits?
They have filed, Your Lordship.
1, 2, 3.
Yes,
5.
Your Lord, all five.
Respondents.
Yes, Your Lordship.
MS so for the petitioners, the petitioner. Further 2 weeks time to file rejoinder.
Much polite, Your Lordship.
Item number 4.
pleases your lordship. Your lordship, this matter we will not
Last
be
opportunity.
we will
You
not
pay
be
cost now since you took time last opportunity last time.
we will not be filing our rejoinder anymore. Let it come up for hearing then, Your Honor.
Yes, party submit that adjournment necessary upon this matter for hearing on so and so.
You shall cause your lordship. Oblige your lordship.
Item number 5.
Lordship, I pray for a week's time to file affidavits, my lord.
Yeah, for 1 and 2.
Yes, my lords.
And for 3 and 4.
Who's upon number 5?
I'm praying for 2 weeks time, Your Lordship.
Why?
There are some documents that I haven't got from my clients.
Who are you? 5 is whom? 5 is whom? 5 is the
Respondent Shala, my lord.
what ex-president you're relying on her support for your case.
No, my lord, I'm not relying, my lord. According to the petitioner, my lord, there are certain documents, my lord, which is required, my lord, which is there with the SMC, my lord, just for that interest, my lord. So we have implemented respondent.
So you want 2 more weeks?
Yes, my lords. 2 weeks.
What about number 4? 3 and 4?
They have already filed.
They filed already.
They filed?
Yes, my lord.
Yes, MS Syam and for 1 and 2 and MS El Majao.
Yes, sir.
For 5, pray for law for a 2 weeks time file affidavit. This is the after and so on.
They applied.
Item number 6.
Six to 19 are connected matters, Your Honor, Lordship.
What about Mr. Pandey? 3, 4 and 5, what's happening?
Lordship, I've received instruction, Lordship. I'm just praying for
What's
2
the
weeks
matter
time,
about?
Lordship.
This is require the land acquisition matter.
Lordship, in Gargoyles.
You're appearing for whom?
NHI DCL, respondent number 3, 4 and 5.
Why taking so much time? 3, 4 and 5?
Lordship.
2 and 6 is filed.
No, Your Lordship.
State hasn't filed, Lordship.
Not been filed. What about 2 and 6? Yes, so respondents pray for now for a 2 weeks time to file affidavit. Yes. Expected the next week or next date the affidavit will be on board.
Lordship.
Yes.
Most obliged.
20.
Lord, for respondent number 1 to 6, we have filed our affidavit, my lord.
Filing my affidavit during the course of the day.
You filed?
We have filed, my lord.
They have filed, Lordship. I've received the copies from the respondents.
All the respondents?
Lordship.
You have for number 7.
Yes, Lordship, I'll be filing during the course of the day.
Is already this is this the affidavit?
Yes,
7.
7, yeah.
Yes, Lordship. Yes.
I've received the
You will file
affidavits.
rejoinder?
I filed rejoinder.
Mr. Amanam Pure pays will not require rejoinder to the affidavits filed by all the respondents. This subject to week.
obliged.
21.
This is Archival.
Come here.
Respondent number 4 and 5. We've just received a notice on Saturday, Archival. Just give us time 1 week to file a power.
What's the matter about, Mr. Bhavante?
You want to hold the bank vicarious liability for the fraud committed by employee, Lordship.
Vicarious liability?
Yes, Your Lordship. For the fraud committed by an employee of the bank.
Okay. You're paying for the bank.
I'm appearing for us. They are
Mr. Madoff?
Yes,
4
my
and
lord.
5. So power will
You're
not.
appearing for whom?
We are put RBI, my lord.
For the
We have received instructions, my lord. So in the meantime, we will file a vocal.
As far as we are concerned, there are 2 branches, 4 and 5. 4 is Ranja branch, the other 5 is Molai branch. So as on today, Archival, we are not sure whether we're going to represent both or one of them. So
Why
just
not?
give us 1 week. Just give 1
What's
week.
7 been served?
7 has been served, Your Lordship.
Who's appearing for 7?
It's private respondent, Lordship.
Who's appearing? Anybody appearing today? Let's see. 4 to you're paying for 4 and 5. You're for 6.
Yes, my lord.
Yes, Mr. Marpan has entered appearance today on behalf of respondents number 4 and 5, and Mr. Murdoch on. Murdoch, right?
Yes,
Number
A, Murdoch.
6. Stop. Where you say they've been served? It's not
As per
reflected on
the
the sheet. Office note's not there.
as per the GPO's
Have you
CIS.
file affidavit?
No, Your Lordship, I'll be filing my affidavit of service.
Please, then be light to obtain status of service to file an affidavit on respondent. Save service for 7 and to file service affidavit if necessary. Stop. Respondents pray for allowed.
To file a power 1 week time.
2 weeks. 1 week.
Not 2 weeks.
2 weeks, yes. This or 2 weeks. What about state?
State lordship is we are not required to file affidavit. Lordship. We place the question before your lordship.
Lordship.
22.
My lord, I'm appearing this matter for private respondent number 456. My lord, as per the information I have, it seems, my lord, that your lordship cannot take up this matter as
Why?
it's related directly or indirectly to late Latomanic's aim.
Where is that written?
As per that, in that matter, election petition, lordship. This election
What is
petition.
that? Correct?
Yes,
Yes,
that.
How,
But
how is the present petitioner related to?
he is the, if I'm not mistaken, is the nephew of late Latomanic's aim.
No, what is your objection, Mr.
Well, the similar matter is being taken up by my lord. It was listed yesterday also, my lord. Before it was already pending for hearing, my lord. Same issue, my lord.
That is the reservation that the respondents.
What is the issue?
Well, the issue is that they have filed several writ petitions, my lord, against the election of the present aim, my lord. Then the writ petition was withdrawn. They have sought a liberty to file a election petition. So that was allowed by this honorable court. Then they have approached the district council.
You didn't take objection earlier on when you came before this
No,
court?
my lord. One more matter is pending, my lord. This is WPC 77 of 2024. It was listed yesterday for hearing, final hearing, my lord. Same matter, my lord. Different petitioner, my lord.
Then?
My lord, this is the information, the instruction I received from my
parties, my lord. It's up to your lordship.
From respondents number 4, 5, and 6 that they have this reservation.
Let's go to another court.
They have reservation.
Yes, as Mr. Dokrut has submitted that this bench might be incapacitated to hear the matter, disabled in view of earlier, in view of the fact that what?
That this matter is directly or indirectly
No, you give the
related
the
with
case. Which case is this?
Case that previous matter.
No, the case where you said that was taken up by this court, which
I
is related to this matter.
My lord, I
was
have the
recused.
specific. There are several matters.
But the client should give specific information also.
Yes, Your Lordship. I do not have the specific. But I can provide, Your Lordship.
Item 77, the WPC 77 of 2024, my lord. Same subject matter, my lord.
No. Mr. Dokrut saying there's another matter which this court has recused. Correct?
No, Your Lordship. It seemed that as per the instruction that I received from the respondent, saying that there are some similar matters related to late Latomanic's aim that Your Lordship
How related to
those
late
had
Latomanic's
taken
aim?
had taken that matter
No,
in
this is related. How related to
this,
the late
because the
aim?
allegation in this election petition is also related directly and indirectly to late Latomanic's aim from that time.
Expired, my lord.
Yeah, he has expired, but that is the reservation. Yeah.
No, you showed a connection, Mr. Dokrut. Because you see, nowadays the court just doesn't recuse just because we can't allow bench hunting. Just because maybe you don't find it comfortable in this court, maybe you know,
No, Your
to make
Lordship.
a submission.
No, Your Lordship, not that. I received this instruction from my.
No, they're not
client.
comfortable. Maybe not you.
Yes.
Your clients are comfortable. That's the only thing.
That there was some several matters.
They'll be put to a disadvantage if the matter is heard by this court.
Your Lordship, then kindly allow me. I'll take proper instruction
Take
from
proper
them.
instruction.
Yeah,
Which
and then
matters?
I'll come
Because
back. Yes,
if it's not
Lordship.
linked, if a person's dead and gone,
Yes, Lordship.
and this is a new matter,
Challenge.
matter,
Yes.
then how can we drag a dead person here?
Yes, Your Lordship. The direct person cannot be dragged, but
Then?
can
you make him a party in your?
No, we didn't make a party also even in the election petition. But it seemed that the matters are related, and he is the nephew of late Latomening Same. That's the
same issues pending before your
I will take proper instruction, Your Lordship, and then I will.
You can't be poor fellow is dead and
Well,
gone.
interim order is there, my lord. 9/6 passed by this honourable court.
Yes,
my lord.
Mr. Doctor has submitted for this court that perhaps this matter may be disabled. He prays him not to obtain proper instructions in the matter. It's just after 2 weeks.
Well, the interim. Well,
23.
Find out specifically, you take proper instructions.
23.
My lord, this matter,
Verified job plan.
verification has already been completed. My lord, we file a report. We'll bring it on.
I have instructions that they have conducted the verifications.
We'll
So
bring it
anything
on.
remains for consideration.
Lordship, they'll have to file a report. Let's
file
see.
it.
What they've done is, Lordship,
With that verification of job cards has been done. He is allowed to praise the report before the court next date. Yes. Whether allowed this and so and so.
The 26 also, my lord, somehow connected with this matter. So 26 is in hearing matter, hearing list.
26. Because if the verification report is accepted, then election should be conducted.
Election can be.
When is connected this matter?
Yes, Your Honor.
Okay, let's together. Let's list together next day.
Obliged.
Hearing supplementary list item number 4.
Where's Mr. Changreso? I don't think you have any more submissions to make. No submissions. Only Mr. Nongbri is hearing for 10 minutes.
My difficulty is I have not yet filed my affidavit because what your lordships was hearing, the issue which your lordships were hearing on is on the maintainability, on which I had nothing to submit, my lord. So, my lord, on merits.
One thing, considering your position, you're just a beneficiary, correct?
Correct, my lord.
So, main ground has been taken by Mr. Changreso with regard to the merits also.
Yes, my lord.
On public functions and alternate remedy. So, take your call. You want to file a small affidavit?
I would prefer to, my lord, because otherwise I'll try to impress upon your lordships that our association has been in existence since 1982, my lord.
Oh, that part, that aspect.
Yes, my lord.
You file it, we file it within 1 week.
We'll file a short affidavit, bringing all these facts on record, because as on today, my lord, we are the only qualified association, my lord, because we have a golf course, while the petitioner does not, my lord. And it is of common knowledge that all tournaments that are held, my lord, it's held in the Shillong golf course, which belongs to the Shillong Club, my lord. And the members of Shillong Club, my lord.
But I think from submissions of the petitioner at the time that this is defunct association.
No, my lord. It's not defunct, my lord. It has been in existence since 1982. It is because of the my lord, the dynamics of golf, my lord. Previously, golf was introduced in the Olympics in the year 1900, my lord, and again in 1904. After that, my lord, it was not a sport in the Olympics. It is only in 2016, my lord, after 112 years, that the golf has been reintroduced in Olympics. Therefore, my lord, the relevance, and it is only in 2016.
So how is relevant with Shillong Golf Association and Olympics?
It is relevant, my lord, because, my lord,
your players straight away go for Olympics. It's not that. I'm just saying because that was a submission. Just to clarify the report that they said that this Shillong Golfers Association has been defunct for many years.
That is incorrect.
They were recognized by the Indian Golf Union because of that fact. They were running all the tournaments for golf promoters. Sorry.
Lordship.
My lord, as far as tournaments is concerned, before their existence, we have been conducting the tournaments, my lord. What had happened, my lord, in the year 2000 or so, my lord, there has been an amendment to the IGU constitution, my lord, to the constitution. Prior to this, my lord, the elections, the electors were the clubs, like the Shillong Golf Club, my lord, who were the voters, my lord. Pursuant to 2020, my lord, everything has changed, and the relevance of the association has come.
Only one question now.
Yes.
These golfers who play in Shillong,
yes,
are they registered?
They are members with us.
Any particular club?
With us.
Or golfers or golfers?
Lordship,
there are
with the
6.
Shillong club. No, just a moment.
Lordship.
With the Shillong club, my lord. And they play in the golf course which belongs to the Shillong club.
No. What this court's trying to, suppose I'm a golfer, right?
Yes, my lord.
I have a membership Shillong club, I pay green fees.
Yes, ma'am.
I go and play. Is it necessary that I affiliate myself to golf promoter or to Shillong Golf Association, or I can play golf?
Well, almost all the golfers are associated to us, my lord.
No, the
in
members.
The state.
No. Is it compulsory for every golfer who plays to be
yes, my lord, for the purposes
to be a member of any particular golf club, every golf promoters or
yes,
Shillong Golf
for the purposes of ranking, my lord, they have to be members of the club. Of the club, my lord.
How many clubs are there?
Lordships, there are 6 clubs.
So all the clubs
and these clubs are
also
affiliated to us.
Only
Lordships.
Shillong club has a golf course in the state, my lord, as on today.
No, that's besides the point. What I'm trying to court's trying to understand is, okay, they are these golf clubs, okay? Like you say, the 6 golf clubs. Now, these golf clubs also can associate with you.
Yes,
Lordship,
they'll come under you.
Yes, my lord. Shillong club is associated with us.
Lordship,
Shillong club. The golf club is saying
the
Lordship,
Shillong
the
golf
6
club,
registered golf clubs are affiliated to our association, and they have to be affiliated.
Shillong club is the main my lord, club, which my lord, the private individuals, my lord, from this society, my lord, I mean from the state, the clubs which they are talking about are all defense, my lord, and they are not even golf clubs.
Lordship,
they are gymkhanas, my lord. They are training centers.
Lordships.
It is of common knowledge, my lord. Golf is played. Yes, my lord.
Week.
I'll do that.
Yes, Mr. Philemon Nongri, learned counsel for respondent number.
Lord, respondent number.
We thought of closing it today, actually. Doesn't matter. Yes, respondent number.
Number 4, Lordship.
Number 4. Praise that he may be allowed 1 week's time to file a short affidavit. Yes.
Highly pledged.
Mr. Angreso, not necessary anymore.
I thought since my first affidavit confines to the maintainability only, the Lordship decide to produce the factual portion.
No, we see that. I'll tell you. Let me tell you why very candidly. Because why this court, after examining and in fact generating a majority of the judge, finds that it's intricately wedded. Maintainability and the merits of the matter.
We understand.
Because maintainability is with regard to the presence of arbitration clause. Correct. And whether you have civil remedy or whether it may be maintainable. So that's the whole thing hinges on that.
Yes,
so once if the writ is maintainable, then that order will be found to be arbitrary.
We understand, we understand.
That is why.
In fact,
that is why this matter was
yes,
yesterday.
In fact, on that point, I would submit, my lord, pursuant to our affiliation of over 2 months, my lord, we have been functioning, my lord. We have been, my lord, conducting activities and in talks with the IGU, my lord. My lord, if your lordships decides that the matter has to be remanded back to to give them a show cause or hearing.
Right.
In that case, my lord, since we are already functioning, my lord, a status quo may be maintained as on date, my lord, because my lord, the 2027 National Games is coming, my lord. We are in preparation. We have the golf course, my lord.
Oh, that's the main. That means the Holy Grail. That's what you all after that.
My lord. So,
my lord, understand, yes.
My lord, may maintain status quo. We will continue to function. If we are out, we will surrender.
You file affidavit.
Yes.
Lord, give me liberty also to file affidavit.
Mr. Angreso also is given similar liberty on behalf of respondent number 1.
Daily list 24. 24.
May it please the Lordship.
Yes.
My Lord, my learned friend has extensively argued on the last occasion, my Lord, and he had raised some pertinent points indeed, my Lord. And I have gone through whatever he has submitted in the affidavit and everything, and I have prepared my written submission as well, my Lord, which will be in fact handy and, my Lord, convenient for my Lords also to decide upon the issues, my Lord. And at the same time, we have prepared certain contentious issues, my Lord, which...
Have you given your...
Yes, I'll be just giving it...
You just see the thing that That is your synopsis.
Now that is including the rulings that I have given in my support, contending to the one which my learned friend has.
Your writ petition, how many pages?
Indeed, one copy I would like to give to a friend.
Yes.
And for government also.
Your writ petition contains 30 pages. I
Yes.
mean, yes, and your
This 172 pages, madam. But obviously including the rulings and the judgments that I have relied upon. Madam. I'll be very short, madam, because the points and the contentions are also indeed very clear.
If it's there, we'll examine. You don't need to make any further submissions.
Yes, madam, you can, but only one aspect I would just like to, madam, point out relating to one. My lord, a point which my learned friend has arisen pertaining to my maintainability regarding whether this writ petition is maintainable or not, because what he has submitted that there has been significant delay on our part, my lord, that we have not approached this court on time, and since this my lord, the scheme which was adopted was in the year 2011, and MTDC was adopted on 5th of July 2011 and was made effective from 7th of July 2011, my lord. So what he's trying to project is that we did not approach in 2011, my lord. So there has been a significant delay of 11 years, my lord. However, my lord, we beg to disagree with my learned friend on the small count, my lord, because the judgment which my learned friend has relied upon was passed by my lords. Just quickly, if I may take your lordship to that judgment, my lord. My lord, it was decided by my lords in a writ petition dated, my lord, sorry, a writ petition number 246 of 2022, dated 6/3/2024. Your lordship's judgment was rendered on 6th of March 2024. The same judgment which my learned friend has relied upon.
Which one is this?
It's Amanda Basamut.
Which he has relied on. I actually I don't have an extra copy.
Copies here.
Copy,
Yes,
my lord.
I
My
supplied on the last
learned
day,
friend has given on the last occasion, my lord.
WPC 246 of 2022.
There, my lord, the entire, my lord, the judgment rendered by my lords in that case was had referred to a very important decision of the Honorable Apex Court. That is, my lord, was reported on 2008 SCC 648, Union of India versus Sam Singh, my lord, at paragraph number 10 of your lordship judgment. Please take out this judgment. Or Sam Singh. Yeah. No, take it out from here.
Oh, yes.
Have my lords found?
Yes.
My lord, this judgment rendered by my lords, my lord, here, decision of the Honorable Apex Court was, my lord, reflected here at page, my lord, not page, my lord, at paragraph number N, my lord, relevant part.
10.
Yes, paragraph number N, my lord. May I just read this relevant part, para 21 of Union of India versus Sam Singh, 2008, 8 SCC, my lord. It says, my lord, to summarize, normally a belated service-related claim will be restricted on the ground of delay and laches, where remedy is sought by filing a writ petition, or limitations, where remedy sought is by an application to administrative tribunal. One of the exceptions, my lord, this is very important. I'm carving out my case, it falls in this exception. One of the exceptions to the said rule is in case relating to continuing wrong, my lord. So
You're saying it's continuing wrong.
One exception, continuing wrong, where a service-related claim is based on a continuing wrong, relief can be granted even if there is a long delay in seeking remedy with reference to the date on which the continuing wrong commenced, if such continuing wrong creates a continuing source of injury. But there is an exception to the exception if the grievance is in respect of any order, this is very important, or administrative decision which related to or affected several others also, my lord. A third party right is shown here to have been created in this exception, my lord, and if the reopening of the issue would affect the settled rights of third parties, then the claim will not be entertained. For example, if the issue relates to payment or refixation of pay or pension, reliefs may be granted in spite of delay as it does not affect the rights of third parties. So my right squarely covers in the, my lord, ambit of the, my lord, claim that we have made and continuing to make even till today, wherein, my lord, there is no third party right created or accrued which would defeat the right of that third party vis-a-vis my claim, because this is not a promotional case. This is not a case that I'm aggrieved by any seniority list or any gradation list, my lord, because the very next part of this judgment talks about the promotion, if I may read, my lord. But if the claim involves issues relating to seniority or promotion, etc., affecting others, delay would render the claim stale. Doctrine of laches limitations will be applied, my lord. Yeah. In so far as consequential relief or recovery of error, this is not important, my lord. So, my lord, this judgment which your lordship has rendered covers my case, which I could understand.
Do
and
you
also
feel that it's personal only to your case? It's not going to affect anybody else?
Absolutely not, my lord. Because
what about the delay with regard to that period of 2011 which have come at that point of time, and whether you can cover, whether you have any relief against FTDC at all at this stage?
Yes, my lord.
That's the only thing that you have to address.
Yes, my lord. So there is one more aspect which I'll correctly address to your lordship's query, my lord. The point regarding my case not coming from 2011 to 2021. My first representation was in 2021. Now, why, my lord, in between my pension, my issues relating to my service, counting my past service, was also before this honorable court, my lord. That was in 2021, 22, somewhere where I have given the order of lordship. Now, that period was a period in which, my lord, a query came from this court that whether the past services rendered by this petitioner in giving her the benefits under the old pension scheme should be counted. So their finance department of the government of Meghalaya clearly indicated that yes, for counting pensions under a notification, you can claim those past services. So that came as a help for me. Why I'm saying this, my lord? Because in order to assess, now this will take us straight to the scheme under the Act. Why I'm saying, my lord? One argument which was advanced by my learned friend was also in relation to whether this scheme can be applied prospectively or retrospectively. We never have ever in our argument or have stated that this has to be given a retrospective effect, which was wrongly constituted by them. What we are saying, my lord, the scheme clearly says that it will be given effect prospectively. But, my lord, there is a proviso to that. The screening committees which are meant to be formed, here I would like to refer to the point which your lordship has just stated. What did I do in between from 11 to 16, 11, 21? They were under the obliged duty to form screening committees, my lord. Screening committees from the day of the inception of the scheme. They never, in fact, in my case, they never constituted any screening committee to examine my case. Meaning thereby, it is not the obliged duty of the incumbent to make an application before them and say that you screen my, you examine my case, my lord. It is their prerogative to examine the cases by constituting screening committees. Okay. So for all these years, there was no screening committee, at least to my knowledge, insofar as the claim of the petitioner was concerned, my lord.
So at a point of time, even in the absence screening committee, you were prevented from making any sort of agitate for your.
No, my lord. I could have ventilated my grievance, my lord, right. But what I'm trying to project, my lord, is that the fact that if they would have had constituted screening committee on time as per this scheme that has been promulgated by them, my lord, that has been implemented by them, my lord. Now, if they would have called us for examining our case on time, then this question would not have arisen. Because what I could learn from some relevant records which my client has given, that like me, there are other incumbents whose cases were examined immediately after this scheme was implemented. So I have those records also, although, my lord, that issue did not came before, only when my learned friend submitted on the other day. So what I could find that from 7/7/2011, there were at least many people working in different grades who were given ACPs, who were called, whose cases were examined, and they were also promoted. So what kept them, my lord, what kept them under, my lord, what I mean to say is that they did not came with any reasons to show that they had not considered my case. So what prevented them from considering my case, my lord, if they really had constituted, my lord? Just one example, my lord, if lordship may kindly see.
But can we take cognizance of this now?
That is absolutely, these are matters of records, my lord. So I just wanted to just refer it to your lordship, just to show that the delay part, if at all it was on my part, cannot be attributed to me, my lord. I have highlighted this part, my lord. These are some of the incumbents serving in different categories under them. So just quickly, lordship may see, a promotion was given in the year 2011, 17.5, 8.11, 2075, and ACP was granted on 8.18, 2012, and again second ACP to the next incumbent, Mr. As, was given in 15.7, 2017. Then, my lord, may quickly come to most important point I would like to raise, my lord. Page number 6, if your lordship may come. There was another incumbent, Mr. Bendik Marwin, who was serving there as a class 3 category employee at page 6, my lord's found. So in 21/5/1989, he joined, my lord. And then ACP first was granted on 7/7/2011, which means the date of implementation is the date, effective date. Now, the second ACP was granted in 21/5/2013. Now, what I'm trying to project is that I'm not only trying to project that parity should be drawn between us and these people who have already been given the benefit. At the same time, my lord, why my case was kept pending for last 11 years is also another issue which they need to answer, my lord. It's not on us that I should be explaining my reasons for delay, my lord. Now here, my lord, if my lord sees, another at page 7 as well, another incumbent, my lord, in fact, two incumbents, serial number 4 and 5, who were appointed in 1986 and 1988, were given their first ACP 7/7/2011, 7/7/2011, and second ACP also they got in 7/7/2011 and 7/26/9/2012, my lord. So my humble submission is that, my lord, so long as, my lord, delay part is concerned, it is not maintainable, my lord. I would humbly submit, my lord, my rights have been continuously being violated, my lord, and it is even continuing today, my lord. And for all these years, my lord, the respondent authorities ought to have constituted a screening committee. Now, where is the option of screening committee, if I may take your lordship?
See, the thing is that now, this point is brought up by respondent.
Yes,
that does not appear anywhere in the pleadings, correct?
No, yes, my pleading, my
It
lord.
does not appear at
Just
all.
I'm just arguing because
with regard to the constitution and screening committee,
correct,
which
my lord,
would have examined your case.
My lord.
Now in this your case liberty of pleadings, now you've produced additional materials. So how is the court to reconcile your additional materials and your additional pleadings, which is not on record?
Exactly. So that is why my lord, my submission would be in this point would be, my lord, as my learned friend in his affidavit also have not pleaded pertaining to the delay ground or maintainability ground. So I was about to come to this point, my lord. If they have not pleaded in their affidavits that...
So that could not address that at all?
Of course not, my lord. Simple. Of course not. Because the burden was on them to bring the point of maintainability. If at all, then your lordship would have admitted this case at the time of admission, giving a preliminary hearing on maintainability. Then the matter would have taken for complete hearing on the merits of the case. Now we are on the merits of the case, my lord. Just because my learned friend had argued on the last occasion, so my lord, I'm just addressing before lordship that point is not necessary to be taken at this stage, my lord. Because anyway, this wrong is continuing. That cannot be denied.
Any pleading with regard to delay, Mr. Sen?
Nothing, my lord.
My lord, may I just explain this why? As I had said right from the start, there is no pleading against me. There is no prayer against me. I have made it very clear in my affidavit. Please have my affidavit for a moment, my lord.
No, just submit, yes.
Just a moment, my lord. So there are three very specific points that I have taken. Number one is that this case suffers from the defect of non-joinder of parties. This has not been addressed by them. The second point was that there is no prayer against me, specifically pleaded in my affidavit. Now, during the course of the hearing, they tried to address the entire case against the state government. After the state government concluded its arguments, they changed the entire focus on us. That is why I had to alter my argument. How do I change my arguments, my lord?
Then file additional affidavits.
My lord?
You have to take the entire...
my friend is now agitating new points, my lord.
No,
please
of
see,
course,
my friend is referred to these documents.
Yes.
Now, when did it come to his knowledge? Why did he not raise his grievances before this? None of this has been addressed. So therefore...
That is why this court was saying, what went agitating at that point of time?
Exactly.
If these things were happening.
And my lord, so look at the writ petition. He's not seeking any relief against me.
I'll come to that
So
point.
what was the
He's
necessity?
seeking to
And
morph, you know,
now,
whatever his his service in MDDC and claiming relief against the state.
yes, Lordship.
That is what you're trying to. You're
They are
to
trying,
morph your,
yeah.
your relief in such a way.
Ultimately, they are state under Article 12, my lord. They cannot shirk their responsibility out by
No, we
shifting.
can't have broad-based arguments.
Lordship.
No, I'll have to confine myself. So even if I confine myself, my lord, with all due respect to what my learned friend says, I can show before your lordship that the first ACP that was, my lord, that I was entitled to receive was way back in 2005. Why I'm saying this, my lord, the scheme clearly says when it is prospectively applied, the screening committee will take into consideration my previous services, my lord. It is not that I will have to start giving my services from the day the scheme is adopted. What they are trying to show that since this scheme is adopted in 2011, my future days are going to be counted for consideration. How can that be, my lord? My past services will have to be counted. So what did they do for last so many years, my lord? So,
yes.
If I, my lord.
And my lords, as far as the 2 points are concerned, I have raised the question of maintainability. This is pleaded in my case very clearly.
In your affidavit.
In my affidavit, my lord, which is I was saying, please see my affidavit. Those 2 points. Affidavit filed by the respondent number 6.
Yes.
Please see page 2, para 5.
Yes.
That's one. Then please see page 4, para 13. I have also said that she has not rendered continuous service. This is on a question of fact. And the last point, my lord, is at page 7. With regard to the fact that there is no prayer against me and that the case is therefore not maintainable. So I have raised this point. To say that I have never agitated this is absolutely incorrect. And as far as the question of delay is concerned, even if I don't plead it, it doesn't stand waived. That is the discretion of this honorable court. Simply because the parties do not plead does not mean the court cannot go into it.
Yes, then we'll reserve a judgment.
Lordship, Lordship.
But you give your bullet points.
I have already submitted, my lords, on the last date. Those 8 points.
Yes, madam.
Lordship, the state will be also allowed to put it for bullet points in one case.
Yes. Hearing concluded. Petitioner and the respondent 6 submitted bullet points. List the matter after 1 week submission of bullet points by the state.
By the state. Highly obliged.
Highly obliged, madam.
27.
Yeah, come. Yeah. Put the file, come. Be careful.
Where's the Shulai?
Your Lordship, if this matter can come up after some time, Mr. Shulai is on legs.
What's the matter about? He'll come, I think, by the time. Start, Mr. Sahu.
Yes.
It's for hearing.
Yes.
Just give me 2 minutes. Huh?
start करें.
Yes.
My lord, in this case, this is the petitioner says executed one construction work on river Dabua in South Garo Hills area. So, as per the bidding document, I have participated in the tender document. Being the lowest bidder, I have been selected as the bidder and I have been allotted the work order also to execute the work of the bridge, construction of the bridge. So, this agreement was executed in 2007, 1st of October 2007. That was the work order was issued on 1st October 2007. And thereafter, I took up the matter and completed, and by obtaining time extension from time to time, there is no objection or dispute on this matter. And I complete the bridge as per the tender document. There is no objection raised by the department. Meanwhile, 3 running bills have been prepared by the department, the state PWD roads, and that has been passed to the National Highway Authority for clearance of payment. That has been also released, payment has been released during this period. And the last final bill, the fourth RA bill, running bill, so that is final bill. They have verified the matter, completed, everything is complete. They have sent to the National Highway Authority regional office at Guwahati, but due to some internal probe difficulties there, they have noticed. So the
internal difficulties,
problems, there been some verifications, that checkings, like that. That was not there. Clarifications.
Your work not been measured.
Yes, everything is there.
There's no confusion or no dispute, measurement of the work.
There is no dispute. Page number, my lord, at page number 8, they have issued the completion certificate also, full satisfaction. Page number 8.
Amount due?
Amount due. At page number 8, they have issued the completion certificate.
Yes.
In my compilation, last compilation is submitted, the documents has been arranged in page number 8. Previously it was scattered manner that was filed, so I have compiled in the.
Yes.
So in page number 8, the completion certificate issue.
Just by executive engineer.
Yes. So till then there is no problem. Then when I submitted by the 4th running bill, final bill, and they submitted with the National Highway Authority regional office, and regional office sought some clarifications. But thereafter, this state PWD officers, they kept quiet without any action from their side.
So 2014 was the date of completion.
Yes.
And where's the last running bill?
Last running bill is the bill number at page number. Page number 47. Page number 47 of the compilation. 47.
Yes.
Annexure PR5.
Yes.
This is the last final bill. That has been prepared and submitted with the government of, that has been prepared by Meghalaya at page number 49. And this sent to the regional officer, Ministry of Road, Transport and Highways on 16 December 2014.
So that is gross amount 3 crores. Okay. Right.
And out of this 3 crores, 1 crore 16 lakhs has been released during
from this final bill itself.
From the total bill 1 crore. So remaining the amount balance is 1 crore 66 lakhs 47,165 is remaining to be payable by the department.
Okay. This was as on?
As on the last fine
when
completion.
was the last payment with you? That one, now the balance is 1 crore 66, correct?
Yes.
Now when was the last payment given to you? That half of this amount?
Last payment was paid in final bill 3 on 47. Last payment bill is made on 31st March 2013. That is reflected in page number 69.
Of this compilation?
Okay, compilation. Running bill CC3 dated 30th September 2012. Date of payment is 31st March 2013. The total payment has been made out of 1 crore.
Last payment. So the last payment you received?
Last payment.
Okay, last payment received.
In 2013.
Yes.
This is the chart they have prepared by the department.
Yes, okay. Okay, yes, then?
Thereafter, we pursue the matter. Then we submit our escalation bill, price escalation bill also as per the tender document. That is also received in the department that no action has been initiated. They kept quiet. We follow up the matter time and again, time and again. 17 reminders has been issued during this period. 17 reminders time to time.
So you apart from the 3 crores, there's some other additional amounts that you have claimed.
Price escalation.
That is price escalation.
And some security deposit.
That amounts to how much?
Price escalation 1 crore 19 lakhs.
So you see, you still to get 1 crore 66 lakhs, correct?
Yes.
1 crore 66 lakhs plus you have a price escalation of
1 crore 19 lakhs 83 919.
Now you can say 1.2 crores escalation.
Yes. And amount withheld from the second running bill 1,72,783. And 8% security deposit has been deducted from the running bill 10,57,296. And 2% earnest money retained by the department 6,01,000. So total amount comes to 3 crore 4,62,163.
Just come again. 3 crore.
3 crore 4,62,163. I have prepared the chart at page number 2, my lord, in the compilation.
Okay.
That is there.
Page 2 at the bottom.
Page number 2.
2 at the bottom.
Have they agreed with escalation also?
Yes, there is a contract. There is no dispute on that. There is no objection. Nothing.
The regression path would be agreed.
Yes. There is
means
no objection.
Your case is not on any disputed fact. Your case is that your final bill was paid, final payment was made to you, outstanding was still 1.66 crores.
Yes.
And then escalation also, he had furnished a bill of nearly 1.2 crores. Then you have your outstanding security deposit and so on and so forth. So the thing is that this amount is admitted amount that they owe you, the 3.4 crores. 3 crores for
4,62,163.
3 lakhs for years.
Yes.
This admitted amount.
Admitted amount. But they are keeping silent without any action.
Okay.
This is my case, my lord.
There is no question of any re-verification
Nothing.
or additional work to justify
No,
escalation.
another small additional work was issued. That is also they have paid, released the payment also. There is no dispute.
There's no question of that. We cannot release your bill because you have to, there are still doubts with regard to.
No. Nothing. No objection has been raised.
Okay.
They are keeping silent without any action or any explanation or reply.
Yes. Yes. Where's Mr. Shulai?
Your Lordship, he's on legs in court number 1. Your Lordship, his matter is going on.
It'll take some time.
Yes, Your Lordship.
You completed your part of the argument, no?
Yes, ma'am.
You have taken note of his arguments.
Yes, Your Lordship.
Last time I have also given the.
They say there's no disputed facts.
Yes, Your Lordship.
That all the bills claimed by them, work started 2007, completed 2014. Then what they said that There's the case that's undisputed. Certified bills not been paid. This one. Let him reply tomorrow or something. Yes. You'll conclude your part.
Yes.
Yes, Mrs. House.
And my lord, I have submitted all documents.
Very good.
Citations also there. They have raised regarding limitation. So I have given the citation of the Supreme Court decisions. In Article 226, limitation is not applicable unless there is a laches on the part of the petitioner.
So
That
you
is
say
also
from
there.
your side there's been no latches?
Yes, my lord. Yes.
Yes.
So
arguments for certain petitions completed. Mr. Ndishula AG's reply tomorrow.
Abhaish, Your Lordship. 27 and 28 connected, Your Lordship.
27, those both are the same.
That's for another contract.
Yes, another contract.
Another bridge.
Bridge.
And what's the amount outstanding there?
4 crore. UN sir. 4 crore 8 lakhs 30,688.
Okay.
Similar actions, no action from the department side.
Next.
29.
You for the respondent or for the
39, 20.
you for the respondent for the petitioner?
Petitioner, Your Lordship.
Were you not MS Yangi's Jude?
I was, Lordship.
Oh, you were?
39?
Yes.
29.
29. Oh, apologies, Your Lordship. I thought it was item number 39.
29.
Who's disseminate?
May it please, Your Lordship?
You want some accommodation?
No, sir. He's coming, sir.
She's arguing the matter. Who's coming?
SD.
Yes. Yes, where's MSD Yangi?
Please, Lordship, she's coming. She's going to send her.
Yes.
May I please, Your Lordship? My Lord, here the petitioner was terminated from his service, my Lord, on a pretext that he has misappropriated an amount of 10 lakhs, my Lord. He was a branch manager of Khandoli branch of Meghalaya Rural Bank, my Lord. He was appointed in the year 2007, my Lord, in the Meghalaya Rural Bank, my Lord. In 2018 to 2021, my Lord, he was posted as a branch manager in the Khandoli branch, my Lord. And on 13/9/2021, my Lord, one RM, my Lord, regional manager, he has conducted an inquiry, my Lord. And he found, my Lord, there was a misappropriation of 10 lakh rupees. And I was the branch manager, my Lord. Now, if my Lord may kindly see the report which has been given by the regional manager 1, my Lord, that is on page 42, annexure 1. Letter dated 13/9/2021. The second para, my Lord, is important.
Yes.
On inquiry from both the branch manager, I am the branch manager, and the office assistant so and so about the dispensary detected, the office assistant admitted that he had misappropriated the cash from the vault without the branch manager knowledge, and that he promised to make good of the shortage, my Lord. And then, my Lord, on the basis of this report, my Lord, I was...
Who's the office assistant? This Almekishla?
Yes, my Lord. He is admitted. Now, my Lord, if my Lord may kindly come to page 44, my Lord. On the basis of this report, my Lord, on 14 September 2021, my Lord, I was suspended. And suspension order is on page 44, my Lord. If I am permitted to read, my Lord.
Yes.
Richmond Ricardo Lalu, Scale 1 officer, is reported to have committed serious certain serious irregularities during his tenure as the branch manager of Khanduli branch from 16 July 2018 to 14 September 2021, and the same is under investigation. In view of the above circumstances, the undersigned, as a competent authority hereby, place so and so, currently posted as Regional Officer 1 under suspension in terms of the Regulation 46 of the Meghalaya Rural Bank Officers and Employees Service Regulation 2010, which effect from the date of this order. So, my lord, last two, my lord, where I was allowed to get some allowances, and my lord, I was directed not to leave the station, my lord. Now, my lord, on this, my lord, I was called for an explanation. That is why letter dated 7 October 2021.
Yes.
I was given an opportunity before they draw the department proceeding, my lord. An opportunity was given for giving me the explanation, my lord. I have given that is on page 46, my lord, and I have denied, my lord, on my first paragraph. If my lord may kindly produce the first paragraph.
Okay, this is fine. What happened? There was an inquiry.
After the inquiry, my lord.
Inquiry report. What does it say?
The inquiry report, my lord. The inquiry was conducted, where, my lord, I was not given with the inquiry report, my lord. And then, my lord, I was also not given the brief of the presiding officer. And, my lord, the allegation which was leveled against of me was not proved, my lord. On the basis of that, my lord, they have terminated me. If my lord may kindly come, my lord, to the termination order, my lord.
Now, let's see the inquiry report. What does it say? What's the recommendation of the inquiry report? You mean to say that
Yes,
during the inquiry proceedings, you're not given adequate opportunity to defend yourself?
Yes, my lord. I was not given because the documents.
Because we're not setting the appeal over the judgment.
Exactly, my lord. Exactly.
The law. You just have to point out whether illegalities were there in the process that is, that we can interfere. Otherwise, nothing.
Exactly, my lord. Exactly. My lord may kindly see letter dated 17 January 2022. That is page 47 and Annexure 5, my lord.
Yes.
This is the proceeding which was drawn against of me, my lord, and charge of articles was supplied to me. List of documents was supplied to me, and the statement of impugnation of lapse allegation against me was supplied. If my lord may kindly come to page 50, my lord.
So you're given the articles of charge,
yes,
your statement imputation,
yes, my lord.
The documents, all materials are given to you.
Yes. Now, my lord may kindly see page 50, my lord. These three things which vitiate the entire proceeding, my lord, because they have given me the list of documents, but these documents were never supplied to me.
Which documents?
This branch register pertaining to cash, receipt scroll and other areas of branch operation. RO letter dated so and so reporting the alleged fraud by the regional manager. This is two things, my lord, these documents. And the list of witness, my lord. The list of witness, my lord, the regional manager was never examined.
So your allegation is, so you say listed documents were not supplied?
Yes, my lord. This list of documents was not supplied to me, my lord. I have written to them. Even then, my lord, they have allowed me to peruse it, my lord, but it was never supplied, my lord.
The witness not examined?
Yes, the witness was not examined, my lord.
Which other witness was examined then?
The regional manager, my lord.
No, any witnesses were examined?
No, no witnesses was examined.
That's fine. There will not be a disabling feature, yes.
Now, my lord, may kindly come to Annexure 7, my lord. Annexure 7 is page 53. By this letter, my lord, I was informed, my lord, that a disciplinary proceeding will be initiated against of me. And my lord, Deepak Sinha Roy, as an inquiry authority, he was appointed, my lord. And one more person was appointed, my lord, Sri Wankar, who is at present posted as manager so and so to represent the bank, my lord. Then, my lord, I have appointed my defense representative, and there was 3 dates of inquiry, my lords. The first date was 21st May 2022, my lord. That is on page 58, my lord. On this date, my lord, the inquiry was supposed to held, my lord, but it was adjourned. The department proceeding could not be initiated because the defense representative was approved, my lord, but the inquiry authority could not get his approval order, my lord, so it was adjourned. Then I was informed, my lord, by letter dated 25/5/2022 that the inquiry will held on 30th May 2022, that is on page 60, my lord.
60.
60, my lord.
Yes.
If my lord may kindly see the table number 11, my lord.
11.
There's no serial number, but I'm just counting it.
Yes.
As pointed out in the charge sheet, serial number 3, the list of documents and the witness based on which charges are framed is available for perusal by the CSO, that is me, my lord, after obtaining approval from the controlling authority. However, as the CSO has not sought for perusing the same, hence the DR is not in a position to present the fact in defense of the CSO. Therefore, the DR has sought for the documents as mentioned in Annexure 3 of the charge sheet, white letter dated so and so to the inquiry authority. However, no response was received till date, my lord. On this date also, my lord, the inquiry was adjourned, my lord. Now, my lord, I was appointed subsequently, my lord, that the inquiry will take place on 13/6/2022, my lord. That is on Annexure 17, my lord. Annexure 17, page 64, my lord. If my lord may kindly peruse page 65, my lord, that is relevant, I want to point out. Column number 4, my lord. As already mentioned in the CS.
Column or row? This is okay. Yes.
DR to IA, my lord. As already mentioned.
Yes. As already mentioned.
Yes, ma'am. As already mentioned in the CSO reply to the allegation number 1, the CSO has not misappropriated the cash, but however the so and so were brought for other branch to fulfill the disbursement needed of KCC, and this is not much relevant, my lord. The next line and the next column, my lord, row.
What's the relevance of one regarding cash limit?
Here, my lord, is all about that how much money was there, my lord, that it could not be ascertained.
What happened to Arme Kishla?
Arme Kishla, my lord, he is facing a trial and he has been terminated also, my lord. He is not before this honorable court, what I was instructed, but I don't know how far it is correct. Now, my lord, may kindly come to page 66, my lord. Page 66, my lord.
Where's the findings?
I'm coming to this, my lord. This is very important, my lord. Page 66, my lord. The third row, my lord, the last third row, my lord. Yes, I am fully satisfied with the proceeding and would like to thank all the parties for their cooperation in the inquiry.
So satisfied with proceedings?
Yes, my lord. Just a minute, my lord. Please prepare now, my lord. The point comes. Please prepare the brief. This by the inquiring authority to the PO, presiding officer, my lord, and also the defense presentation, and submit a copy to me. One copy to the brief to be submitted is to be handed over to the CSO, that means me, my lord, and the DR who was defending me, my lord. This was never done, my lord. It was never been furnished to me. Now, my lord.
No, but it's over.
No, my lord.
On the date when you said that Are you satisfied that
I was satisfied till that point, my lord.
I've been given to defend your case. Yes, I'm fully satisfied.
Yes. Now, my subsequently it comes, my lord.
How we can be satisfied if the inquiry has been concluded?
No, my lord. What happened, my lord? There is a judgment of the Honorable Apex Court, my lord, which says, my lord, once the DP is over, my lord, and if they are contemplating to impose a major penalty against me, my lord, they have to give me a show cause.
Yes.
They have to give me a show cause.
Not necessarily. They can give a court inquiry report if you have.
They have not given me. They have not given me the inquiry report. They have not given me the brief. This is my case, my lord. Now, my lord, may kindly see. Now, on 28th June, my lord, I was informed, my lord, that I was terminated from the service, my lord. Now, on 30th, my lord, I was communicated on 30th June 2022, my lord. I have been communicated by a speaking order that is on page 69. 69, my lord. 68 is the letter by which I was communicated. Now, my lord, may see what are the documents which was placed before the authority, my lord, who has taken into consideration and terminated me from the service. Investigation report dated 22nd September 2021. And, my lord, department inquiry report 21st June 2021. This was never furnished to me, my lord.
That's the only case.
This is 2 points, my lord.
Is that admitted, Ms. Yang? That,
yes, Your Lordship.
That the inquiry was not given.
The inquiry report was not given to the
I'm
charged officer, Your Lordship.
I have 2 more points to make, my lord.
I'll take Your Lordship to
now, my lord, may kindly see when I have filed an appeal, my lord, my first appeal.
This speaking orders by the appointing authority, correct?
Yes, my lord.
Yes, chairman.
This chairman, my lord.
Yeah.
Now, my lord, on page 71, annexure 20, my lord, I have filed an appeal. In the appeal, my lord, I have pointed out in page 74 that, my lord, these documents was not furnished to me.
Yes.
And the witness was not examined. The documents was not exhibited, my lord.
No, witness even listed, not necessarily examined.
No, but
suppose sometimes you put up even some witnesses, you find that you don't.
But no one was examined. No one was examined to show, my lord, this much amount was misappropriated.
That we're not going to go into that. We'll go into the technical.
My lord, may kindly see. Then I have said this appeal, my lord. On the basis of this appeal, my lord, on page 76, they have communicated me a letter whereby, my lord, the board, the competent authority is the chairman, my lord, who has informed me that the board has perused and noted that you have not been furnished with a copy of the presiding officer brief, owing to which you could not submit your defense brief.
Yes.
Then they said, my lord, therefore the board will be reviewing your appeal after your defense brief has been submitted. Now, my lord, the defense brief was given to me. My lord, may kindly take note of this, my lord, that inquiry report, they have not said anything about the inquiry report, my lord. Now, my lord, may kindly see the brief, the brief which was given to me, my lord, is on page 77. 77, 78, 79 and 80, my lord.
There's a presenting officer's brief, not the
Yes,
defense.
yes, presenting officer's brief. Sorry.
Yes.
Now, my lord, may kindly see.
So, what do you want to show in 37?
What I want to show, my lord, is this. Inquiry officer remark. What is his finding? Nothing has been mentioned there, my lord. It has not been filled up also. Even, my lord, my remarks has not been filled up. And they have relied on this document, my lord. What was my counter to the allegation which was leveled against of me has not been filled up.
What format is this? Part of the rules?
Your Lordship, this is the presenting officer's brief, Your Lordship. The inquiry officer's remark is filled up in the inquiry report.
Is standard template or is just made for the purpose of this case only?
This is made for the purpose of this thing, Your Lordship. And the inquiry officer's remark, Your Lordship, is in the inquiry report, Your Lordship. This is the presenting officer's brief where the inquiry officer has not given any remark here.
This was considered, my lord. This document was considered by the competent authority, but this columns was not even filled up and placed before him, my lord. My lord, after supplying me the brief, my lord, I filed my appeal, my lord, for the second time. And I have pointed out in page 85, my lord,
your second appeal you filed.
The first appeal was not considered because the brief was not supplied to me. So this they have considered, my
First
lord.
appeal rather.
Yes, my lord.
Yes.
So I have rebutted all those allegations leveled against of me, my lord, and I have also pointed out it is Karmiki Shilla who has misappropriated the amount, my lord. Now, my lord, may kindly see. Thereafter, my lord, on 18 January 2023, they have passed an order where the chairman and competent authority has informed me that the board has considered my appeal and they have dismissed my appeal, my lord.
Where is that page?
That is on page 89. 89, my lord, is a speaking order. 18 January 2023.
Yes.
Now, again, my lord, may kindly see investigation report which they have relied, dated 22nd September 2021. Was never supplied to me till date, my lord. And my lord, may peruse page 90.
Investigation report.
Yes. Investigation report was never furnished to me, my lord. And department inquiry report was also not furnished to me, my lord. And this is an admitted position, my lord.
But we had a copy of this inquiry report.
No, my lord. It was not furnished to me. It was not given to me, my lord.
But after the first appeal, I mean after the...
No, it was the brief which was given to me.
Presiding officer's brief
Was given to me, not a report, my lord.
Okay.
They have not given to me. Now, my lord, may kindly see page 90. The appeal of so-and-so dated 4 August 2022 was put up to the board of directors at its meeting held on so-and-so, and the board has noted that he was not furnished with a copy of the presiding brief, owing to which this, my lord. Then, my lord, the next paragraph. Having therefore considering the gravity of the lapse committed by so-and-so, is the petitioner, I, in my capacity as a competent authority, ordered that as per regulation this, my lord, I was terminated, my lord, from the service. Now, my case is this, my lord, when it is an admitted position that RM has said, my lord, regional manager who has not been examined, he probably, my lord, if he would have been examined, he could have given a statement in my favor, probably, because he has in his statement, my lord, in 161, my lord, 164, my lord, before the criminal trial, my lord, in page 99, he has stated, my lord, that it is Armiki Shilla who is responsible for the misappropriation of fund. Page 99, my lord. Para 2, my lord. When I reached Meghalaya so-and-so, the last 3 lines, my lord. The moment I saw that the cashier Armiki Shilla confessed that he had misappropriated a sum of so-and-so, and there I asked him for which time there was a shortage of the cash, and he told me that it was since the month of February 2021. My lord, in 161 statement also, my lord, he has said in page 100, my lord, he has stated, my lord, the RM who was not examined, my lord, he has stated, my lord, that it is the Armiki Shilla who is responsible, and I am not aware of the misappropriation, my lord. I am aggrieved with the process, my lord, which has been adopted by the inquiring officer, my lord. First thing, my lord, they have not supplied me the documents. The inquiry.
But the statement of witnesses here at page 100.
Which one, my lord?
This is which inquiry?
No, this is regarding the criminal trial. Criminal trial, my lord. They have stated in the criminal trial. The disciplinary proceeding was prejudiced, my lord, because my lord has observed that, my lord, they have not given me the inquiry report. They have also not given me the presiding officer brief, my lord. When the first authority is a competent authority who has decided the entire thing, my lord, on the recommendation of the inquiring officer, my lord, they have not given. On that, my lord, I have a judgment to place, my lord. That is State of Uttar Pradesh versus Mohammad Sarif, my lord, that is reported in 1982 to SSC. Page 376, my lord. No, I am going to.
Absolutely.
1982.
Here is
So your whole case is just on reasonable opportunity to defend yourself.
Yes, my lord.
Adequate opportunity as well.
Yes, yes,
If
my
the inquiry report not
The
given,
head note
only
says, my
the
lord.
presiding officer's brief was given to you, and some certain documents not supplied to you.
Yes, my lord.
So and then
And the department proceeding get vitiated, my lord. Now, my lord,
That's only
my lord, may kindly see the head note itself, my lord. Fifth line, my lord. Copies of the statement of the witnesses recorded during the preliminary inquiry not furnished to him at the time of the disciplinary inquiry. So, para 3, my lord, is the full they have given. They have said, my lord, that after hearing the counsel appearing for the state, we are satisfied that both the appeal court and the high court were right in holding that the plaintiff had no reasonable opportunity of defending himself against the charge leveled against him, and he was prejudiced in the manner of his defense. Only two aspects need to be mentioned in this connection. Admittedly, in the charge sheet that was framed and served upon the plaintiff, no particulars were with regard to the dates or time of this allegation misconduct have been entered. Government forests, this is not relevant, my lord. This is not relevant, my lord. But the sum up of this judgment is this, my lord. If the statement of the witness and the preliminary inquiry report is not given to me, my lord, the entire thing get vitiated, my lord. The landmark judgment is of 1993, my lord. Volume 4, reported in
Is the idol?
No, manage. Yes. 727, my lord. I'm relying on para 26, 27.
This is a very celebrated judgment.
Yes,
What do you
yes.
think that there are other judgments after this also?
I was able to get this judgment only, my lord.
The output is a lead judgment. The others also after this with regard to
That-
expand the scope as
And-
whether in some cases when inquiry reports not necessarily be given also to come certain findings.
Yes, my lord. I am relying on one more judgment of this is the latest, my lord, 2004. I was able to get this 2004 judgment, my lord. It was NCT versus Anjan Kumar Shah, my lord.
Volume
7, my lord. Page 581. Para 9, my lord. They are saying, my lord, that non-supplying of the inquiry report. Opportunity was not granted, my lord. They are saying in para 9.
What does your model rules prescribe in department proceedings?
Your Lordship, in this, I just want to make some brief submission and then I'll come to my this thing, Your Lordship.
Two more
Your
judgments,
Lordship,
I will rely, my lord, before my learned senior start.
Yes.
Yes, my lord. One is of the Kerala High Court, my lord. Kerala High Court, my lord. Of 2022, my lord. Yes. Para, if my lord may kindly produce para 7, my lord.
Hmm.
And one judgment I will rely, my lord, where is in a contempt proceeding, my lord. There's some finding was given.
Contempt proceeding?
Yes, my lord. In the contempt proceeding, where they have relied on this 1993 Supreme Court judgment, para 5, if my lord may kindly.
One second, let me just.
Which is the thing? Where was it reported?
It's a Meghalaya judgment.
Meghalaya judgment?
Yes, my lord. In of 2014, my lord.
One second. Because see, the thing is that this Kerala judgment also just cut paste the initial judgment.
1993, yes.
Yes.
Para 5, if my lord may peruse, para 5, my lord. They are also relying on the same judgment of 1993. But my lord, I will rely on para 6, my lord, where, my lord, the court has given a finding where again, after a lapse of so many years, my lord.
Not going to go into contempt jurisdiction then.
My lord. But they have given an observation for that.
That is. That's the only thing, non-supply inquiry report. Yes.
Non-supply of inquiry report, Your Lordship, is aware, Your Lordship, that it does not ipso facto vitiate the proceedings, Your Lordship. He has to prove and plead prejudice, Your Lordship, which he has not done, Your Lordship. And then
how has he been prejudiced? Report, if the inquiry report is prejudicial to the
that is for him to prove, Your Lordship.
Officer or employee, then it has to be furnished. If
no, I agree, Your Lordship. Yes, that was a mistake. Yes, that was a defect.
The defect is he does not have to plead prejudice. The very fact that it was prejudicial against him is not furnished. That means it has become.
No, Your Lordship, that I admit, Your Lordship, but that alone does not vitiate the proceedings. That is what I'm saying.
So how do you say that?
But let me, Your Lordship, first take Your Lordship from the beginning. Yes. Then I will come to that, Your Lordship. Now, Your Lordship, the petitioner here was a branch manager of Khanduli branch, Your Lordship, and he was, as a branch manager, overall in charge of the branch. He was a joint custodian of the vault key as well as the cash, Your Lordship. Now, Your Lordship, there was a snap inspection on 13/9/2021 by the regional manager, which they do every now and then, and it was found that in the cash balance register, the balance shown was 18,35,769. But when the actual cash was, physical cash was counted, Your Lordship,
only 8 lakhs something was there.
Only 8 lakhs was there. And then when the matter was brought to him, he pleaded ignorance. And it was this Armiki Shullah, the office assistant, who said that I have this, but be that as may, Your Lordship, as the joint custodian of the vault cash and the cash, he was,
responsibility.
He had not conducted his responsibilities, and there was therefore some mistake on his part, which he has admitted, Your Lordship.
If he didn't take the money also, he is liable. He's
but
a manager,
because he is liable, Your Lordship. It is his duty to... that is his responsibility,
Your
Your
case
Lordship.
is that since the facts as they stand undisputed,
yes,
non-supply of inquiry report will not vitiate, will not...
But, Your Lordship, I will take Your Lordship to that also, Your Lordship. Now that he is not... then the charges were framed, Your Lordship. Charges were framed, and he had not been giving the branch manager's monthly certificate. That was one of the charge. Then there was dereliction. There was a dereliction of duty, Your Lordship, on his part. And then the money, he has not performed his duty, because as a branch manager, especially when public money is involved, Your Lordship, the extreme honesty and integrity and discipline in work is required, Lordship. In fact, Your Lordship, there are judgments for even temporary removal of the money for a night also, Your Lordship. The branch manager has been dismissed, Your Lordship, in these matters, Your Lordship. And in this case, Your Lordship, my friend has said that the regional manager was not examined. He was cited as a witness, no doubt, but all these documents, Your Lordship,
that's not
that is not a thing, Your Lordship.
You can put 10, 15, 20 witnesses also.
So, but the documents were exhibited. The documents were presented and exhibited by the presenting officer, and these documents had been perused.
and that these documents may not, the copies may not have been furnished to him, Your Lordship, but he was allowed to peruse. And when the inquiry officer also asked him, that was also brought to Your Lordship's notice, he said, I'm satisfied with I have no complaints. It was only after he in fact, Your Lordship, has admitted his guilt, not that he has misappropriated the money, but in his letter, in his reply to the show cause, Your Lordship, he has admitted that Annexure 6, Your Lordship, to the writ petition. Annexure 6, at the end, Your Lordship, at page 52, while he has given a reply when he was called for explanation as to the irregularities in the branch.
Let's see your rules.
I'll show Your Lordship. Then he has said, Respected Madam, I admit to have failed to have discharged my duties as desired by the bank, but would like to state that I have no malified intention to cause any loss to the bank, and I pray that I may be spared any severe action as the main culprit.
The quantum punishment he's been terminated.
He has been terminated, Your Lordship.
So the quantum is not too harsh.
No, Your Lordship. It is not harsh because he, as a branch manager, is guilty of dereliction of duty, Your Lordship. From February 2021, Your Lordship, there was shortage of cash in the branch. But it was not reported to the controlling authority by him. He has suppressed all that, and it was only when inspection was conducted, then it was found that there was a shortage of cash. In fact, he should, as a branch manager, he should have reported it to the controlling authority or filed an FIR, Your Lordship.
Yes.
Whether he has suffered any loss or any profit, Your Lordship, by this is also immaterial, Lordship. But the fact remains that there has been dereliction of duty, there has been misappropriation of money, and that the bank has suffered, Your Lordship. In this regard, Your Lordship, I have actually Your Lordship wanted to see the rules.
So he's suspended. He was terminated since when?
Terminated since 2022, I think.
2022, my lord. January 2023, my lord, I was terminated.
Your Lordship, I can give I don't think I have got a copy.
See, to get around this hurdle, you have to come with some authorities.
I have some authorities, Your Lordship, where it clearly says, Your Lordship, the High Court is will not reappreciate the evidence, which is already their number one.
At, they're not sitting appeal.
In appeal, correct, Your Lordship. It is settled law.
The only thing is that the High Court is to balance
the thing, Your
The thing
Lordship.
is that now, whether he's
and
been
Your
given
Lordship, if Your Lordship feels,
if the law demands that inquiry report, if it's prejudicial to the inquiry, now that this changed. Sometimes even in some cases, natural justice does not come in at all. If infraction is such that even natural justice can be given a go by or can be overlooked, if the infraction of such or an action is such that demands certain kind of actions.
Your Lordship, I have got some citations.
Done away with.
Then if Your Lordship finds, no, in fact, I admit, Your Lordship, that there was a defect in this non-furnishing of the thing. But what I'm trying to say is that
statement itself, my lord, vitiate the entire proceeding, my lord.
If it vitiates the entire proceedings, Your Lordship, Your Lordship can send back the matter, Your Lordship, for a fresh disciplinary proceeding, or from the day, or from the stage where it was vitiated, Your Lordship. But the petitioner cannot be reinstated, nor can his back wages be allowed.
We have the other authority to show that he cannot be reinstated, because if the final order is vitiated.
In 2025 only, Your Lordship, I've got the Supreme Court ruling, which it says, Your Lordship, that even if the court finds that there has been some irregularities or deficiencies then he cannot be reinstated.
No, Mr. Day's client is that it just be rewinded to the period when the inquiry was completed and inquiry report submitted. Leave aside the documents you're already privy to them in the inquiry proceedings because you're satisfied, with the proceeding. Only from the stage of
From the stage where it was...
inquiry report being given to you, it's like a second show cause, you represent against that, and then the order of dispute authority be final, that's all.
One thing which has fallen from my learned senior, I don't want to be very harsh on this point. But my lord, we can only see the conduct, my lord, where, my lord, they are so adamant that I should not be allowed to be reinstated.
No, but that is the law. That is the law. That is the law.
My lord,
you have conducted an irregularity.
My lord may kindly appreciate. My lord may kindly appreciate. My lord may kindly appreciate. It is their officer who are saying that I am not responsible for the misappropriation. Maybe I have my duty. I have not complied with my duty, my lord. But it is not me who has misappropriated the fund.
Your rules.
Your rules are here, your lordship.
Your major penalties and minor penalties.
This is a major penalty because he has not followed the rules and regulations.
You have all authorities with you today.
Sorry, your lordship.
You have all authorities with you.
I have not compiled them, your lordship, but I have got this authority of Chairman Life Insurance Corporation versus A. Masil.
That is a known judgment also. We'll continue tomorrow.
Tomorrow, your lordship, I'm not be here. Day after tomorrow also I'll not be here today. I'm just going for a medical thing, your lordship, to Guwahati.
Okay, we'll continue on Monday, but
Monday
it will
will
be
be
authorities
okay.
also. Because that's the only thing, like, where there are some cases also where if the infraction is such an extent that even natural justice
Then I'll give
can be given a go by. If the materials present are so overwhelming, there are some judgments.
I will look.
That'll be against you, but then it's for
my friend to
2022 is there, lordship. It says that reinstatement cannot be.
You kindly give yes, part heard list on Monday for the hearing. Yes.
Supplementary 1, item number 1.
Please, Lordship. Very narrow scope of challenge, my lord. I'll be very brief on this issue. I'll just take your lordships to the bid, my lord. To the bid documents, my lord, which is at page 20. My lords have it. So this is a bid floated by the Department of Urban Affairs for construction of a mini secretariat at Tura.
Yes.
Now please have page 22. These are the key dates, my lord. At the fourth row, your lordship will find the last date and time for receipt of bids. That's 25th of June 25, 2:30. And time and date for opening.
You already submitted yours.
I have not submitted, my lord.
Then?
I am precluded from submitting, my lords. And if I do submit, and if they find that there is a case against me, then I'll be debarred for 3 years. So please see, time and date for opening bids is 25th June 2025. This is for technical bid. For technical bid, my lord. Tomorrow, my lord. Yeah. And my lords, they've said at the bottom, my lords, will find the footnote. The firms that qualify technically shall be notified and subsequently for opening of the financial bid of the financial part of the bids.
Yeah.
And please see the instruction to bidders at page 28. Yes. Point number 3, my lord, corrupt and fraudulent practices. This reads, the Department of the Urban Affairs of the Government of Meghalaya requires compliance with its policy in regard to corrupt and fraudulent practices. In further pursuance of this policy, bidders shall permit and shall cause its agents, whether declared or not, subcontractors, subconsultants, service providers or suppliers or any other personnel thereof, to permit the Department of Urban Affairs to inspect all accounts, records and other documents relating to any pre-qualification process, bid submission and contract performance in the case of award, and to have them audited by auditors appointed by the Department of Urban Affairs. Intending bidders must not be placed in the negative list of firms of any department, organization for any reason, including failure, abandoning the project without permission of the department, organization, unethical practices, failure to abide by integrity pact, or failure to follow any lawful directions given by the department, organization. Now this is important, Lord. A bidder whose proprietor, partner, director, organization is having any FIR, police case, CBI case, any ongoing cases on due to corrupt and unethical practices during tenders, execution of contracts, or was barred from participating in the tenders during execution of the contract in any central state government organization or central state PSU, or autonomous bodies or public listed company or private limited company, government or PSU work agency shall not be allowed to participate in the tender process. Let's I'm agreed with this. Just notice one thing, my lords. They are only excluding a person who has a pending case, not excluding a person who has been convicted. This is completely arbitrary and unreasonable and violative of Article 14. There's just one judgment on this particular point of the Honorable Calcutta High Court.
Its implication is there. Yes. Yes.
My lord, please see the 5th page, my lord. Similar situation. The petitioner herein was sought to be disqualified simply on the basis there was a case pending against him. My lords, we at page 5. These are the terms of the contract. That's Roman 1, page 5 at the bottom.
Yes.
May I read, my lord? A declaration in the form of an affidavit should be submitted on a non-judicial paper of ₹10, duly affirmed before the notary public, first-class magistrate, should be submitted stating clearly that on the date of submission of the tender, there is no pending FIR charge sheet against the tenderer in respect of an offence under the Prevention of Corruption Act. If any such case is declared in the affidavit or otherwise discovered, the applicant's tender shall be cancelled summarily without assigning any reason whatsoever. Then please see, my lord, page 8. My lord has it. The second paragraph. May I read, my lord? To my mind, the writ petitioner herein has not been found guilty of any of the offences in respect of which the FIR dated February 10, 2012 has been lodged against it. To disqualify a person from participating in the tender merely on the ground that an FIR is pending against such person will impugn upon the right to livelihood of the person concerned. The person concerned may be validly charged and may ultimately be found to be guilty, but till such time that the person is found to be guilty, he is presumed innocent. A disqualification to participate in a tender to which the person concerned is otherwise eligible to participate should not be introduced, to my mind, on the basis of an FIR or a charge sheet. That is to say, on the basis of an allegation in respect of which the tenderer has not been found to be guilty by a competent court. Then please also see para 9, the second paragraph.
Yes.
In my view, the state cannot consider a person to be guilty unless it is established that he is guilty of the offence that he is charged with. The state is seeking to debar a tenderer who is otherwise qualified to participate in the tender on the basis of an FIR charge sheet in respect of an offence under the PC Act. In the instant case the FIR is under challenge, the writ petition in which challenge to the FIR is thrown is pending adjudication. The interim order dated 16th March 2012 restrains the concerned authorities from submitting any charge sheet final report without the leave of the court. In such circumstances, to find that the writ petitioner herein will be disqualified from participating in the tender, since an FIR charge sheet against the tenderer in respect of an offence under the PC Act is pending, will infringe upon the right of the livelihood of the writ petitioner. The contention of the government pleader that clause 3.1 is not absolutely arbitrary, mala fide or unreasonable requires consideration. In my view, the state authorities cannot discriminate against a person and debar him from participating in a tender on the ground that there is an FIR charge sheet against such tenderer under the PC Act. Till such time that the tenderer is found guilty under the PC Act, the subject clause does not prevent a person who is found to be guilty under the PC Act. It is directed against a person against whom there is an FIR charge sheet under the PC Act. So therefore, the state authorities has limited scope of clause 3.1 to a category of persons against whom only there is a pending FIR charge sheet under the PC Act. The state authorities, therefore, in terms of clause 3.1, has no objection to deal with a person who is found guilty under the PC Act. Clause 3.1, as it stands today, will only disqualify a person who is found guilty under the provisions of the PC Act 1988. The high moral ground that the state urges in support of clause 1, therefore, has no basis at all. As the clause 3.1 stands, the state authorities has no objection to deal with a person convicted of an offence under the PC Act, but will debar a person yet to be found guilty merely on the ground of a pending.
Yes.
Lordship,
Mr. Pati.
Yes.
Yes, what do you have to say? Please put on your audio. Yes. Yes.
Yes, yes, Lordship, I'm audible now?
Yes, yes.
Yes, my Lordship, may I please take to the 2 pages which my learned friend started with. Page 92 first, my Lords, the list of dates, the important dates of the tender was invited on 15th of May 2025, my Lords. That is 40 days ago, about 39 days ago.
That's what that go against him, yes.
19th May was the sale of period for sale of bidding document. So for 1 month, this person is sitting, and only on the last day of the closing of the bid submission of bid documents, the petitioner has approached the court, leaving no time for examination on its case in merits.
No, one thing, Mr. Pati, did he come with any petition after the issue of tender regarding the selling tender conditions? He hasn't. He never came and represented against tender conditions. Well, that's allowed all tenders now. The intending bidders also, if there's need some clarification or something.
There was a pre-bid meeting also. Those of conditions was there.
So he did not. That means he did not.
Never
nothing.
Nothing.
Yes. Correct.
I did not participate in the pre-bid meeting.
No, he didn't raise.
No.
Suppose he intended to participate, he didn't come with a petition.
Correct.
You see,
I did not
so many tenders floating here. Many cases which is dealt with also. Where corrigendum is issued again, if they find it is offensive, a tender clause is offensive, then you challenge the tender clause. But not Mr. Sen, I think it's.
But again, my lords, I would very humbly submit, my lords, merely because I've not participated, that does not mean I cannot challenge the validity of these particular clauses. I can bring a challenge.
You can challenge it, but then you should have taken the right recourse. If they are the owners of the contract, rightly or wrongly, they have stipulated some criteria. The criteria now is given that if you're offended by any criteria is there, you say, okay, fine, suppose it limits suppose it's tailor-made contract or it's limited to certain people which you feel should not be done like this. This is your case. You should have done for them that this clause is offensive.
Limited prayer, let them allow me to participate on the basis of this.
What's the point? You reject your tender.
No, my lords, which is what I'm saying.
Yes.
If your lordships find that this particular clause itself is unreasonable, I have every right to then participate.
See, the thing is that this is a public, I think it's for a public building.
My lord.
This kind of thing.
Lordship, I understand.
What is the quantum? What is the...
150 crores. The value of the contract? Yes, my lord. The value of the contract. Now, please, my lords, only just see that the time for opening of the bid, the technical bid is 25th June, but as far as the financial bid is concerned...
Your submission is that you took permission to move this matter last week.
Well, but may I just clarify that was in respect of a different petitioner, my lord.
The court has to take counsel of that.
No, that was not in respect of this petitioner, my lord.
Given that permission is not, you didn't move to recall the.
I sincerely apologize, my lord.
By the court, you moved it now in the 11th hour.
No, well, what had happened, that was in respect of a different petitioner.
Fishing expeditions.
True. That was in respect of a different petitioner, my lord. This is a completely different petitioner. Kindly don't hold that against him, my lord. This is a different petitioner altogether. There was a different petitioner in respect to whom I moved the mention memo. My lord, ask them to at least...
You said that, sorry, we couldn't move it because of some reasons I'm moving it.
Yes, my lord. There was a different petitioner, my lord. I'm not suppressing that information.
No, it's okay. But even the 11th hour, Mr. Sen.
But at least keep my petition pending. Let it be considered, my lords. Or allow me to participate.
You see, in this public contracts now, the thing is that they're the owners of the contract. Whatever, they might prescribe some crazy conditions also.
Yes,
that means that's subject to correction by a petition.
It's not subject to judicial
fault. It's a fault of the petitioner. But also, if they've seen this clause, the tenor has been up there since 15.
No, well, it's also it is judicial review is still open, by this honourable court, which is why I was referring to a judgment of the Calcutta High Court. It is a very well considered judgment, and it points out that it's violative of Article 14.
That was well within time.
Perhaps, my lord. But then, my lord, merely because I've come...
You see, it's a different set of circumstances. This case, what happens is that the FIR has been challenged itself, and charge has not been filed. The thing is that the whole proceeding, like although the investigating authorities have been allowed to go ahead with investigation, but the other proceedings have been put on hold. And so in those circumstances, what is the person to do?
True. The facts are dissimilar, my lord, but if your lordships look at what the court has held, is that the clause itself is violative of Article 14.
But then the thing is that we can't, every case has a different color and flavor. So in this case, you've come 11th hour, we can't stall the bidding now.
There are also cases people have come towards the end. I have come well before the bid has been opened.
Today is the last date. By what date? What time?
No, it's opening. It's being opened tomorrow at 2:30.
No, what last date for submission of bid?
Tomorrow.
Tomorrow submission of bid.
Tomorrow at 2:30. So there is sufficient time. It's not the case that I've come after the bid has been opened. Let them file their affidavit, my lords, to at least sustain that this bid is... No, not by tomorrow, my lords. And allow me to participate at least. In case for any reason my writ is found to be not maintainable.
Your lordship,
Yes.
They can participate in future contract. My lords, it is not this contract alone. It's the policy of the Department of Government of Meghalaya, my lords. It's on in all the tenders by Urban Affairs Fund. This is the condition, my lords. And if
No,
you
they
lordship
say,
will give
the thing is that only what
any
we,
criminal.
the court's holding something as a petitioner only on the ground of his laches, this one, nothing else. And laches also a person who's, who has like, committed laches, he can't come and seek relief in the last moment. That's all. That's the only consideration of this court.
Well, I would humbly submit, merely because I've not participated in the pre-bid meeting, that would not...
No. What are the latches on your part?
I'm just saying, not really latches, but I've come well within time, my lords, because the last date is tomorrow.
Contract. Yes, heard Ms. S.L. and the counsel, the petitioner. You should notice who's appearing for the all seat respondents.
Yes, Your
There
Lordship.
are 2 respondents.
Yes, Mr. Tripathi, together as he is present on behalf of
Both the respondents.
no further is called for. The grievance of the writ petitioner is with clause 3.3 as given because right?
Lordship.
Of section 1, instruction to bidders, bracket IDB capital, wherein it is provided that a bidder whose proprietor, stroke partner, stroke director, stroke organization is having any FIR, stroke police case, stroke CBI case, any ongoing cases due to corrupt unethical practices during tender execution contracts, or apart from participating in tenders during execution of contract in any central state, government organization, etc. Stopped. Mr. S.N. submits that the clause as inserted in the instruction to bidders is offensive in as much as the same has prejudiced the writ petitioner, who though a proceedings pending against him has not been convicted.
And no charges have not been framed in that note.
And furthermore, charges are yet to be framed in the matter. He further submits that he may be allowed at least to submit his bid, and the same be subject to
outcome of the petition
of
this writ petition.
Of the writ petition.
And that will not prejudice them.
Yes. Mr. What is your first name?
Mr. Abhijit
Tripathi, learned counsel for the respondents, has drawn the attention of this court. Where is that? 22. Yes.
Page 22 is the other dates.
Yes, has submitted that. In reply, has submitted that the said tender, that is invitation for bids, had been floated since 15th May 2025, and the last date for where is that?
25th June.
Last, where is that? Date, paragraph.
At page 22, 4th row.
25th June at 14:30 hours.
Page?
Page 22. Well, it's page 22, the 4th row. Last date and time for receipt of bids.
Okay, yes. So, no? Stroke invitation to bids, ITB, had been floated since, and the last date and time for receipt of bids is the 25th of June 2025 at 14:30 hours. So we submits that if the petitioner was genuinely aggrieved, he would have approached this court at a much earlier date, but has chosen to come at this late hour which will jeopardize the entire process will jeopardize the entire tender process. He submits that in view of the delay and also the fact that the petitioner has never preferred even a petition to question the tender conditions, the petition is no interference is called for, and the petition will be dismissed. Next paragraph. As on hearing the learned counsel for the parties, it is it is noted that as submitted, the tender condition contained at 3.3 bars a bidder who has a criminal case, a police, or any FIR stroke, police case stroke CBI case, or any ongoing case due to corrupt practices from participating in the bid. Stop. However, it is also noted that the tender or ITB has been floated as far back as on 15th May 2025, and the writ petitioner has preferred this, has filed the petition today itself and sought for urgent listing, which the court has allowed, and as such the matter is being considered. So on consideration of the entire matters, though the tender condition is questionable, the very fact that the writ petitioner never questioned the same at an earlier stage nor approached this court well within time, no relief is permissible at this stage, as the same will jeopardize a project that has been initiated in public interest by the state respondents. We'll dismiss it.
My lords, I would pray, let them file their affidavit, my lords. Allow me to just participate and let it be subject to the outcome of this writ petition, my lord. I don't think it will prejudice them. It will not prejudice, my lord. Kindly
Once
see,
you get
as
a
per
toe in the door,
I'd like to have my foot in the door, my lord.
When you have a toe, when you get a toe in the door,
Lordship,
then you know, then the door will come down.
Let's kindly see, the last date of submission of the physical documents is 2nd July. There is sufficient time.
Yes.
Allow me to only participate.
Which will be open tomorrow itself.
Yes.
No, I understand. Let me participate. I'll file my bid today itself.
Let him file his bids. Yes.
Let it be subject to the outcome, my lord. It will not prejudice them in any way.
That is his main prayer. There is no interim prayer regarding. There is no interim prayer.
Lordship can hold that relief. No. There is. Please see.
No, there is not. The prayer does not say so, my lord. The prayer, interim prayer is stay of the
See, page 12, my lord. I have asked for a stay.
Yes.
Lordship can naturally mold that relief.
The interim prayer made for
interim prayer is only for the stay
for allowing
of the pending process.
writ petition pursuant proceedings, therefore, is not detained, and the writ petition is dismissed. You appeal.
Obliged, my
lord.
Any hearing is ready.
30. 30.
This is a, my lord, I am otherwise ready, your lordship. There is some sense of urgency, my lord. And this is a case, my lord, last time I pointed out, many adjournment has been sought, your lordship. Almost 20 adjournments has been sought in this case. I am ready, your lordship, my lord, subject to convenience of you, my lord.
What's the matter about?
My lord, this is, my lord, which I am for the petition, your lordship.
If I can, respondent number 9, private respondent, it is my appointment that petitioner is challenging through the writ petition, my lord. There's been some, I've received instructions last evening, and there's been some development in the matter, in as much as my appointment has now been confirmed by the government a few days back, my lord. Give me a week's time, my lord, to put it on record.
Upon appealing for whom?
Well, it's I'm for the college.
This is Shillong College?
Shillong College.
No. We'll have to, after a week?
After a week,
yes,
I may be allowed to.
As General Learned Counsel's Permanent submits that there's been some developments in the matter, he prays that the same be adjourned for a week.
I may be allowed to file a small additional affidavit.
Stand over for a week, and the respondent number 9 is also permitted to bring on record the development by way of affidavit. Yes.
The only thing, my lord, the next day, my lord, matter is taken up, your lordship. No further.
Mr. Sen, this court gives you a lot of indulgence. Every matter is always taken up.
That would, now with this development, my lords, it will change the complexity.
Change complexity.
Oh my, they would have to come back with something else.
3.
Any other matter ready?
Lordship, if the matter could come up after 2 weeks, Lordship. Plus,
You're asking for accommodation also?
Your Lordship.
No, you're ready with the matter?
Yes, Your Lordship. Actually, Mr. Majawa was here, Your Lordship.
I don't see Mr. Majawa. Where is he?
He was here, Your Lordship, but then...
After 2 weeks then. If he was here, we would have taken it up. Yes.
Apply, Lordship.
34.
Please, Lordship, this matter, the application under 64 of the land acquisition, we've already filed.
We have to get a copy to hand over to the state to examine. It's
What
a
do you
land
mean?
acquisition matter.
What do you?
The
You
application
only
under
filed
60
application 64.
We've just filed, so that we have
I'm
to
not
hand
aware,
over.
my lord, sir. We've not been served with it.
We'll
It
give
may
them
come
a
up
copy.
next week. I'll just examine the application.
Just on the prayer of Mr. Marpan, this afternoon will be after
Obliged.
1 week. Yes.
Obliged, my lord.
37.
This is a very small issue, your lordships. My lord, and this is also I am ready otherwise, your lordships.
But Sushila is not here.
I'm bringing if this matter may come up next week, Lord.
Tomorrow?
Let it be tomorrow, my lord.
1 week, yes. Okay.
Very much.
39.
Same consultation to all cases, yes. At the request of Susuma, 1 week.
May I
Yes.
please, Your Lordship? Your Lordship, this matter pertains to the death of a student in JNV school, Mauplang, due to the negligence of the school authorities.
Ready your final hearing?
Yes, Your Lordship.
We'll have it then. We won't have to, because today the court specifies for time. I have to go somewhere. We'll have it when?
Tomorrow?
Tomorrow, Your Lordship.
Tomorrow? Pass over the day.
40.
I'll be obliged, Your Lordship.
Please, Your Lordship. Lordship, I pray for some more time this matter, Your Lordship. I need some more time to obtain certain documents.
40, correct?
Yes, Your Lordship.
Yes, you've taken consent now.
Yes, Your Lordship.
Okay. After 2 weeks.
Lordship.